Prepare to begin, please. It's 9 a.m. We are on day 2 of the hearing in DWB 2413, Drinking Water Bureau case with CRRUA. My name is Felicia Worth, the hearing officer. We almost finished 2 of the 9 witnesses that we will be hearing from yesterday. We'll finish Ms. Littleton's redirect this morning, Mr. Rayel, and then proceed through the other 3 department witnesses. And then, as I read your witness list, you identified 6. Sorry, 6 witnesses for CRRUA.
On the list?
Yeah.
Yes.
Okay. And I saw that 2 of them were department witnesses, so you may or may not still need to do that. I'm not asking. I'm wondering, though, whether it's worth having a discussion as to what day we would choose to continue making the record in the event we don't finish with all witnesses today.
And Madam Hearing Officer, it's my understanding from I just discussed with the opposing counsel that they're only going to call 2 witnesses, correct?
Well, right now that's the plan.
Okay.
But, I mean, obviously we're not going to waive the
Right.
to only. We do have witnesses on our witness list as well as rebuttal witnesses. But right now the plan is to call Mr. Lopez and Mr. Crosby. But we do anticipate that their direct testimonies will be lengthy, and I'm sure the cross examination will be lengthy. And it does make sense to look at dates in the event that we need them.
Okay, so we can do again. When I thought we were facing 9 witnesses, I thought it'd be worthwhile to have that conversation before we even started. If it makes sense to have this conversation later, I'm happy to do it later.
That's fine.
Yeah.
Sorry. I mean, if we end up only doing the 5, then there may be a chance we get done too.
All right. Terrific. Let's bring Ms. Littleton back to the witness table. Whenever you're ready.
Good morning, Ms. Littleton.
Good morning.
We're back on your redirect examination. I'm going to ask you just a few more questions.
Okay.
Mr. Trujillo yesterday asked you about the additional water testing that CRRUA is voluntarily performing with arsenic test strips, etc. Mr. Trujillo is trying to say that the additional water testing is something that shows good faith on the part of CRRUA. Do you feel that the additional water testing is good faith on the part of CRRUA?
No, I do not. I think that the testing that is performed there is something that is their normal maintenance of their arsenic treatment plant. It's something that they should have been doing all of these years to ensure that they're providing safe drinking water to their customers. So to say that we need to give them credit for it, I don't think that's accurate, because I think it's something that should be a part of their daily process, and it always should have been.
You testified that you oversee something like 400 water systems.
That's correct.
Do any of those other water systems do that type of additional testing on a regular basis?
They do.
I'm going to object. I believe that she testified yesterday that she wasn't sure.
Okay, I'm asking her again. I don't know if she's done any research in the meantime. I don't know if she's.
Well, in that case, it's a lack of foundation. Because I mean, I think that her testimony yesterday was pretty clear. I asked her that question: how many other water systems do the type of testing that CRRUA did? And she said, "Well, I'm not sure."
Well, I didn't ask her how many. I asked her, do any of the other water systems? So it's a different question.
It is a different question.
So do any of the other 400 water systems you oversee do additional testing to your recollection?
Yes, they do, as just part of the regular maintenance of their arsenic treatment plants.
Okay, thank you. Um, the additional testing that CRRUA is performing now, um, in your mind, is that reactive or proactive?
It's reactive.
And so, does it have any bearing on the penalty that we are here trying to assess today? The fact that they are reacting to the ACO.
I do not.
Object. I'm not sure this proper foundation has been laid for this witness to testify about the civil penalty. She testified she wasn't familiar with the substance of the compliance order. She testified that she didn't know.
Let me rephrase it. Let me rephrase it. In your mind, is it does it go toward good faith or bad faith that they are performing this additional testing? It's kind of the same answer you gave a minute ago, but is it good faith or bad faith that they're doing this additional testing?
Again, I'm going to object just based on the lack of foundation. I mean, I think that this witness testified that she didn't really have any application of the penalty policy. She didn't understand the allegations of the compliance order. She didn't know that CRRUA had, I mean, she just basically yesterday testified that she almost had very little knowledge of any of CRRUA's operations to ask her questions that are specific to the penalty when she yesterday testified knowing almost nothing.
I think that mischaracterizes her testimony. I think it's a little argumentative and harassing to say she testified almost nothing. But
no, I mean, let me
rephrase it. I'm sorry. Let's start it out that way. Let me rephrase it.
Okay.
As the Southern Compliance Officer who oversees CRRUA, is the fact that they do additional water testing now, is in your mind, is that something they should receive extra credit for?
No.
Thank you. Mr. Trujillo asked you yesterday about Mr. Eric Lopez. You're familiar with Mr. Lopez, correct?
Yes, I am.
And you expressed a rather positive opinion of Mr. Lopez. Is that correct?
Yes.
Okay. What is your experience of how CRRUA operates when Mr. Lopez is present?
I think that Mr. Lopez has helped CRRUA get out of this situation twice now that I know of. He has helped them, repair their arsenic treatment plants, help them train their operators on how to run them. And I'm actually worried about what's going to happen to CRRUA once, last time he was part of the water system, they moved him, I believe, to the wastewater side. And then when that happened, CRRUA fell out of compliance again. I think they're doing, I think with Eric helping them out and being there with them and helping them train, I think that it's positive, but I do worry about what's going to happen once he's gone.
Thank you. Mr. Lopez, Mr. Trujillo brought up yesterday that CRRUA, he asked you a bunch of questions about the fact that CRRUA is now back in compliance. Do you recall those questions?
Yes.
Just because CRRUA is now back into compliance with the MCL related to arsenic, does that mean that all of the system's problems have been corrected forever?
No, it does not.
Do you feel that based on the history that you've had with CRRUA that these problems will stay corrected?
I'm going to object to calls for speculation.
I think it is speculative.
I'm asking her to testify to her experience with, or let me, I'll rephrase it. Let me ask it this way. In the past, when CRRUA has come into compliance, have they had a pattern and practice of them falling back out of compliance?
Yes, they have.
Okay. And as you just testified, when Mr. Lopez is not present, you worry that they may fall back out of compliance?
Yes.
Thank you. Ms. Littleton, were it not for NMED's enforcement action that we're here about today, in your experience, do you believe that CRRUA would have taken action to come into compliance?
No,
I'm gonna object again. I mean, like, it's pure speculation.
Mr. Real, yeah, that was speculative as well.
Okay. Um, in your past sanitary surveys and experience with CRRUA, have they voluntarily told you when they're out of compliance?
no, they have not.
In fact, they've hidden that fact from you, correct?
Yes,
Were it not for the fact that you or your colleagues did actual physical inspections and talked to employees and or contractors of CRRUA, you wouldn't have discovered things like the arsenic treatment plants being taken offline intentionally.
yes,
You testified yesterday about J.C. Crosby. Mr. Trio asked you a series of questions about J.C. Crosby. Do you recall those?
yes.
Mr. Trio asked you if Mr. Crosby had ever lied to you, and you responded in the affirmative that he had. In your mind, is it bad faith when the executive director of a water system that you are overseeing lies to you?
I'm gonna object again. I mean, I'm not sure the witness is qualified to testify as to what or does not constitute bad faith, especially with zero context.
I think you laid a bunch of context yesterday, Madam Hearing Officer. I'm trying to establish that.
Hold on. So my memory is that Mr. Trujillo did elicit from her a number of no answers when it came to participation in the preparation of the ACO or the application of the penalty policy.
Well, and also he asked a bunch of questions about how great CRRUA is doing now and how much more wonderful the system is. And so what I'm asking is, when the director of that system lies to you, you talked about trusting CRRUA. When the director of the system lies to you, does that instill trust in that system in your mind?
I definitely do not trust CRRUA because of their past actions. Mr. Crosby did lie to me as to the amount of time that the arsenic treatment plants were being bypassed. I think that the actions that were taken, he was aware of, and they purposely didn't notify us, and more importantly, they didn't notify their customers. Because of those actions, the mistrust there's a lot of effects that happen because of that. I mean, here we are, we're all here because of the actions that they took. I have spent countless hundreds of hours having to handle IPRA requests because of the actions that they took. My staff last week spent the entire week finishing another IPRA request for documents relating to CRRUA and the violations that they've received and the actions that they've taken. The mistrust is deep with me because the time that we've spent handling this situation with them, we could have spent with other water systems trying to help others who are actually trying to provide safe drinking water to their customers. Like I said, the mistrust for me runs deep just because I've had consequences from their actions. And it's not just me. It's like I said, my staff, and I've had to pull people away. I've had to pull, projects that we weren't able to complete just because we were having to deal with the situation that they created.
Thank you, Ms. Littleton. I have no further questions.
Okay. Any reason not to excuse Ms. Littleton?
No.
Thank you very much, Ms. Littleton.
Thank you.
Your next witness.
Madam Hearing Officer, the Environment Department calls Martin Torres.
Hello. Would you, would you state and spell your first and last name, please? Is that on? I don't think so.
Martin Torres, Martintorrez.
Thank you. Do you swear or affirm to tell the truth?
I do.
Thank you.
So speak slower if you can. Good morning, Mr. Torres. Where are you currently employed?
I'm currently employed in the Las Cruces office with the New Mexico Environment Department.
And in what position?
I am the Public Water System Supervision Manager.
And how long have you been in that position, Mr. Torres?
I've been in this position 2 years and 4 days.
Okay, perfect. How long have you been with the New Mexico Environment Department?
Approximately 14 years.
14 years. In your current position, can you give me just a very brief description of your main job duties?
Yeah, I oversee all of the compliance work done within our section, as well as enforcement and data. So that's everything that ranges from sanitary survey work, issuing NOVs, updating sampling schedules, to issuing administrative compliance orders, terminating administrative compliance orders, and working with our data team and making sure all of the water system data that we collect is entered into our CRRUA database.
And you may have said this, but do you also, in your position, conduct inspections?
Yes, we do. Yes.
And can you tell us what CRRUA stands for?
Yeah, it's our Safe Drinking Water Information System.
Thank you, Mr. Torres. Can you tell me who's in the Southern Region Compliance Group?
Yeah, so our compliance section is broken into 2 separate groups. We have our northern staff and southern staff, and our southern staff is supervised by Brandy Littleton. And she has a group of approximately 3, 4, or 5 compliance officers. So we have a person in our Roswell office, Deborah Jones, in our Ruidoso office with Rocio Galvan. We have Las Cruces, Tim Willie, who carries most of Doñana County. And we also have a Silver City office with Cindy Ortega. And at the time of the CRRUA incident, we did have our surface water rural manager under Brandy Littleton, who was Joe Savage.
And you said at the time, is Mr. Savage retired?
Yes, sir.
Okay.
He's currently retired.
And who is in the enforcement group?
Right. It's Maria Medina.
Medina. Have you, in your capacity with NMED, had any actions with CRRUA?
Yes, I have.
When would you say that CRRUA first hit your radar in your position as supervision manager?
Approximately 3 months after my being hired, late November, early December.
Okay. Can you describe how they came to your attention?
Yes. So December 1st, 2023, our technical assistant specialist, Antonio Romero, received an email from Juan Carlos Crosby, stating that they were having some issues in their distribution system of high pH levels and discolored water.
Okay. Can you tell me what happened after receiving that email?
Yeah, after that email was received, we reached out to our leadership team and trying to requesting what actions we needed to take. Because of the high pH issue, we felt necessary that we needed to reach out to the Department of Health, Department of Homeland Security, Doñana County Emergency Response, and then we also reached out to CRRUA. We sent an email to Brent Westmoreland and Ernie Gananza asking them if they could identify the reason why this is happening, what they're doing to mitigate the issue.
Did you receive any complaints from CRRUA consumers?
Yes. So as soon as we
object to the extent that it relies on hearsay.
Overruled.
You can answer.
as soon as we got the email from JC, we started getting inundated with complaints from customers within the CRRUA distribution system of water that was had a color tint to it, had a slimy feel. Um, so, and those calls came in by the dozens.
Um, so after you contacted everyone at CRRUA, what did you learn from them as to what was causing the pH issue, the slimy feel, the discoloration in the water?
Yeah, we got a response to our request from Juan Carlos Crosby, stating that at the industrial park arsenic treatment plant had some issues with their pH probe, and that was somewhat of an isolated incident only in that distribution system of high pH levels. So they went out and they were flushing lines immediately, and they took some pH samples. And I think the highest reading that I remember was 10.68.
What level should the pH be in a water distribution system ideally?
There's not like a specific pH level that we're looking for, but the common value is closer to 7, neutral. So,
and so the fact that it was 10.68, is that what in your mind caused the slimy feel?
yes.
And what was causing the water to have such a high pH level at CRRUA at that time?
At that time, we weren't sure. We just knew, given that it is an arsenic treatment plant, that had something to do within their treatment system.
Okay. That was on December 1st that you received the email?
Yes, sir. All of this is December 1st.
Okay. What did you do next?
After receiving the response from CRRUA, we felt necessary that we needed to go out there, do a site visit / inspection as soon as possible. So we went out December 2nd, which is a Saturday, and to conduct an inspection specifically at the industrial park arsenic treatment plant.
And what? Who was present at that inspection?
It was myself, Antonio Romero. We were accompanied by Araceli Telles from the Groundwater Quality Bureau, and at the plant on CRRUA's side, Juan Carlos Crosby met us there along with Ernest Carranza, who was their lead operator at the time.
And what did you discover was causing the high pH level?
We came to the conclusion that they had some pH probe issues. The pH probe failed, and it wasn't communicating with their controller. So once allowing caustic soda to enter the distribution system. So the caustic soda raises the pH. That's why you're seeing the high levels. And the CRRUA's treatment process, they have to lower the pH to allow the arsenic to precipitate out during the treatment process. And then they inject it again with caustic soda before it goes to distribution to get it closer to 7. I don't know exactly the value they tried to hit before it goes to distribution, but the pH probe was malfunctioned, so it basically didn't stop. It allowed the caustic soda to continue the feed.
Did Mr. Crosby say anything at that inspection to you about whether or not they would be contacting their consumers?
Yes, he did. They actually issued a do not drink order.
Did they issue the do not drink order in a timely fashion?
Not in accordance to the regs.
So it's is it fair to say that Mr. Crosby was in a position of authority at the time of the pH investigation?
As an assistant executive manager, I would say so.
Okay. Did he speak on behalf of CRRUA during the inspection?
He did. Executive manager Brett Westmoreland was contact with him was little to none after knowing about the incident.
Did you hear Secretary Roderick testify yesterday that Mr. Westmoreland basically resigned and disappeared after this incident?
Yes, that's my understanding as well.
Okay. I'm going to ask you to direct your attention to exhibit number 10 in that notebook there in front of you.
Sure.
Mr. Trio, any objection to this exhibit?
Have you entered? You haven't entered this one
I
yet?
have not entered this one.
Number 10?
Yes.
No objection.
Number 10 is admitted.
So, Mr. Cotis, what is exhibit 10?
This is a letter I sent to CRRUA, specifically to Juan Carlos Crosby, of the findings of our site visit that we conducted on December 2nd.
And what's the date of that letter?
This letter is dated January 12th.
Can you explain to us what the findings in this letter and the report are?
Yeah, they summarize the actions the actions we took during the site visit, our findings, like I just mentioned with the pH probe. It also highlights there were some issues that we found on their controller regarding calibration histories and regarding some readings that we typically wouldn't see on a controller.
So you explained that the pH sensor either failed or I think Deputy Secretary Roderick testified that it might not have been calibrated correctly, but for whatever reason, it just allowed caustic soda, you said, to be continuously injected into the water?
Yes.
Okay. So do you know what amount of caustic soda was injected into the water?
When we were on site, we saw their chemical feed tank for caustic soda, and we found the record showing that was 4,000 gallons. So it was, I believe, 67% full at the time of our site visit.
If I represented to you that it was, your report says 62% full, would that be correct?
Yeah, that sounds
okay. Keep going.
Yeah, 62.9% full. I think it was like 37% empty. So that equated to 1,484 gallons of the caustic soda that we assume could have entered the distribution system, creating this pH issue.
And can you explain to me what that means, why it's noteworthy that it was that 37% of the caustic soda had been injected into the water?
It was just our way of determining how much volume or how much gallons of caustic soda could enter distribution. When we were trying to evaluate why the pH is higher than normal, this is what our findings were.
Can caustic soda cause any side effects to the water?
Side effects meaning like feeling slimy, like a soapy kind of feel. Yes.
Okay.
I've just object to lack of foundation. If he establishes foundation for how he knows that, and or if he knows that, something along those lines. But
Mr. Cotis, in your position, have you come into contact with caustic soda and water systems before?
Not enough to, I guess, be the expert and say I physically felt the slimy feel before.
Okay. I'll move on then. In your experience, what other substances can cause slimy feels in drinking water systems?
Yeah, so we get water quality complaints quite a bit, and we do get discolored water and a slimy feel occasionally, and we have associated with those incidents to food grade oil that some water systems use at their wells. The food grade oil likes to collect on top of the water columns on the well, and sometimes a slug of that will get into the distribution system. And initially, when we started getting these water quality complaints before we could identify the caustic soda issue, we thought that might be the case. That was a thought that we had to rule out. However, food grade oil wouldn't elevate pH levels.
So in your experience, it was not food grade
Yeah.
lubricant.
Yeah,
It was caustic soda that was causing the,
yes,
because of the higher pH levels. That's how you were able to eliminate the food grade lubricant.
yes.
Okay.
Mr. Torres, be careful about not stepping on the end of a sentence.
Is the caustic soda leaking into the system and causing the pH to rise to such a high level something that CRRUA should have discovered earlier?
Yes, 100%. Daily operations should have noticed pH levels increasing to that amount outside of normal operations. Daily operations should have caught the issue we saw at the controller was a negative value. That's not normal. So there should have been some alarms going off in their head saying, why is this a negative value? Why is our pH higher? And action should have been taken once they start recognizing those things.
And that's something you would recognize in a normal day-to-day inspection of your system to make sure that it's operating correctly.
I would think so.
Thank you. So then why didn't CRRUA catch it?
I'm going to object. I mean, I think it calls for speculation unless.
I think it does.
Based on your inspection, Mr. Torres, why didn't CRRUA catch the caustic soda issue?
The lack of record keeping that we saw on site during our on-site inspection and lack of calibration histories led us to believe they weren't monitoring these on a daily basis.
Should they have been monitoring them on a daily basis?
Absolutely. Any treatment plant should be monitored daily.
Is CRRUA required to have an emergency response plan?
Yes, they are.
Did they use their emergency response plan as part of this pH level incident?
No, they did not.
We talked about the fact that J.C. Crosby had been notified about the complaints of slimy water. Did CRRUA investigate these complaints on their own?
No, I would say no, just because the amount of complaints we were getting and what the customers were telling us, how a lot of the feedback we were getting was they're calling us because they couldn't get a hold of anybody within CRRUA.
I'm going to object then because it doesn't sound like he has actual knowledge of whether they did or not. I think he's basing it on speculation based upon communications with other individuals not related to CRRUA. I mean, I think that this sounds like speculative testimony in regards to you're asking him a specific question about his knowledge of what CRRUA took place, and he's answering, I talked to people in the public, so I don't think so.
Yeah, yeah.
I'll rephrase that. Based on your communications with members of the public, do you feel like CRRUA had caught this issue and had investigated it in a timely fashion?
I'm going to do the same objection. I mean, I just don't understand how talking to other people would inform him of actions that CRRUA did or did not take.
Let me rephrase it again. Your office received numerous complaints from people about the filling of slimy water.
We did, and
Okay.
This was actually something we did bring up on site, and we talked to JC about being able to respond to the calls and making sure that he had people available to receive the calls over the weekend. So this was something that we did talk back and forth with JC on addressing.
Okay. And did JC indicate that they had discovered the problem, that they had investigated the problem ahead of time before you went out there on December 2nd?
JC acknowledged that the number of calls were hard to answer and respond to all of them. So that was acknowledged.
And you received complaints that people were unable to get a hold of CRRUA, and that's why they were calling your office?
Yes.
Would you say you received a large number of complaints?
Absolutely.
Okay. Based on your investigation, when did CRRUA discover the pH issue?
So our conversations with JC and asking them, interviewing them basically, we found out CRRUA started receiving complaints as early as November 28th, I believe.
And do you know, based on your investigation and your discussions with CRRUA, what did the data show? Oh, wait, let me ask this question. So they started getting complaints as early as November 28th. Did they notify you on November 28th about the complaints?
No, sir.
And they didn't notify you until what day?
They notified us December 1st, 2023.
Did you evaluate the probes in the sensor?
The probes we did not evaluate. We did evaluate the sensor and we pulled all the data. We had to pull the data there and we took it back to our office and to review the data that was housed in the sensor.
And
not the sensor, I'm sorry, the controller.
The controller. And what did the data that was housed in the controller show you as to when the pH issue began?
It confirmed that the irregular values, that negative value that we were seeing on the reading, in this reading, it was pH levels. So we were seeing a negative value for the pH, and we were able to determine that that negative value started being reported on the controller as of November 21st.
And so as of November 21st, 2023, as you testified earlier, if CRRUA was doing their normal daily day-to-day inspection, they should have picked up this pH issue as early as November 21st, 2023.
Yes.
Thank you. What else did your findings conclude of your investigation? What other findings did you have?
Our findings, we also we identified the caustic soda, the data issue. We also identified that they didn't issue the notice to their customers.
So after the inspection, well, were they required to issue a
Yes.
notice to their customers?
Yes.
After the inspection, what action did the department take?
Our actions after the inspection, we issued them a notice of violations because they didn't respond or they didn't let their customers know of this water issue that they were having with the pH. And we also increased their lead and copper sampling.
Did you require CRRUA to issue that do not drink order at that time?
We didn't. It wasn't. I can't remember if we required it or not.
Did they issue the do not
They
drink?
issued a do not drink order.
Just not in a timely fashion?
Yes.
So let me ask you this question. Why did you issue a notice of violation for CRRUA not informing the public of the high pH levels in the public water system?
40 CFR requires that. This fell under a tier 1 public notice violation, I believe. And the reason it fit that category is because anytime a water supply is endangered, the water system has 24 hours to notify their customers.
So can we assume, based on the fact that you issued a notice of violation to CRRUA for not notifying their customers, that they did not issue the do not drink order?
Yes.
And that's why you hit them with an NOV for that?
Yes.
Did you increase sampling at CRRUA at all following this investigation?
Yes, specifically lead and copper.
For lead and copper?
Yes, sir.
And why would you increase sampling for lead and copper based on a pH issue?
Well, typically higher pHs kind of help protect against lead exposure or lead leaching from the lines, creates a protective coating. but because of the pH increase so fast, that could jeopardize that protective barrier. And that's the reason why we wanted to make sure that no lead was leaching from the lines due to this pH issue.
So you're saying that the quick increase in the pH that could have jeopardized it could have caused more copper or lead to leach into the water.
It could have jeopardized the integrity of the coating, the protective coating that was already built in the plant. I mean, the pipes. Excuse me.
And if that coating is jeopardized, then lead or copper could be leached.
Could be leached out. Yes.
Did you increase monitoring sampling for CRRUA
In regards to arsenic?
In regards to this pH level?
In regards to the pH, we did ask for monitoring of pH as they were flushing the system. That was our way of ensuring that the flushing was working and they were able to get water with high pH concentrations out of distribution.
Were there any other actions that you took in response to the findings of your investigation, Mr. Torres?
In response to the investigation, we issued the NOV. We increased the sampling schedule. I don't believe so.
Did you require any modifications regarding an emergency response plan?
Oh, we did require their emergency response plan to address the public notice issue. So we did ask CRRUA to specifically modify or update their emergency response plan to include that.
Okay. Why is failing to notify their customers an issue in your mind?
Our public notices are prescriptive with important information to customers regarding the contaminant in question. So it gives their customers information on what the contaminant is, what actions to take, and so not doing the public notice doesn't give their customers that information, I guess.
Doesn't give them any warning ahead of time to prepare?
Yes.
Is that a violation of the Administrative Code of the Drinking Water Act?
Yes.
Mr. Torres, I want to transition a bit. You mentioned that Ernie Carranza was present at the site inspection conducted on December 2nd.
Yes, sir.
And remind me who Ernest Carranza is?
He was the lead. He is the lead operator for, or at the time he was a lead operator for CRRUA.
During the site inspection you conducted on December 2nd of 2023, related to the pH levels, did you learn any other information about CRRUA's operations?
Yeah, during that site visit, Mr. Carranza stated that the arsenic treatment plant was offline.
Did he state for how long it had been offline?
He said approximately about a year.
Was this the first time, to your knowledge, that NMED learned that the arsenic treatment plants had been bypassed?
To my knowledge, yes.
Was that bypass done intentionally?
Mr. Carranza told us the reason it was being bypassed is because they were waiting for some parts to repair that were on back order, and that was the reason that I'm aware of why the treatment plant was being bypassed.
So your conversation with Ernest Carranza on December 2nd was the first time that you yourself specifically discovered the bypass of the arsenic treatment systems.
Yeah, keep in mind I've only been in this position for 3 months.
Right. So why is bypassing the arsenic treatment plant a problem in your mind and experience?
It allows untreated water to go into distribution. So non-compliant water.
You treat for arsenic for a reason?
You treat water. Yeah, if they're treating for arsenic, it's because they're required to do so.
So by not treating for arsenic? What does that do?
Ultimately, it puts their customers at risk.
How did CRRUA manage to go at least a year without NMED knowing that they had taken their arsenic treatment plants offline?
Um, Water systems can make modifications to their system. And because we only do sanitary surveys every 3 years, those modifications, turning off treatment plants, adding new wells or new facilities within those 3 years can go unnoticed, unreported.
In regards to taking an arsenic treatment plant offline as opposed to adding a new well, are they required to notify you if they take their arsenic treatment plant offline?
Yes, any treatment changes we should be notified. If it's a new well, if it's a new treatment plant, if it's taking off a treatment plant for an extended period of time, yes.
And that's per the drinking water regulations.
Yes.
So you said that J.C. Crosby and Ernest Carranza were both present at the time of the pH inspection. Was anyone else present on behalf of CRRUA?
No, sir.
Would it be fair to say that Mr. Crosby had the authority and the ability to call and report that bypass of the arsenic treatment plant in the same manner that he reported the pH levels to you?
I would say it would be fair, but it'd be unfair just to isolate him. There was other people with that knowledge starting from operations.
So should someone from CRRUA have called and notified the department that they had taken the arsenic treatment plants off?
Yes, sir.
And did they do that?
No, sir.
And you already testified that Mr. Crosby and Mr. Carranza indicated that they knew that the arsenic treatment plants had been bypassed?
Yes, sir.
In your history with CRRUA, what does CRRUA's history demonstrate to you in your position regarding their compliance, regarding their coming into compliance with NOVs and ACOs?
My history as in my position is that they struggle to maintain compliance.
They come in and out of compliance?
Yes.
Is that demonstrated by the record?
Demonstrated by the record, the amount of administrative orders and NOVs that they receive.
Does the fact that the treatment facilities were intentionally taken offline and bypassed demonstrate anything to you?
The fact that the treatment plant system was taken offline and there was no communication to our department and to their customers sets off some alarms and raises some concerns regarding the culture that allows that to happen.
The culture within CRRUA?
Yes, sir.
Would you agree if I were to ask you that, well, let me say it this way. Based on your experience, would you agree that the only reason that CRRUA is complying right now with the arsenic treatment is because they got caught?
Based on speculation.
How would you rephrase, please?
Based on the fact that CRRUA did not voluntarily report the arsenic treatment plants being offline, would NMED have discovered that fact were it not for your inspection?
We would identify that during the sanitary survey that was conducted.
Would CRRUA have voluntarily told, did CRRUA voluntarily tell you that they had taken it offline?
No.
And what does that demonstrate to you?
That demonstrates, like I said, just a lack of, it's hard to say if they didn't know, if they should have. I don't know if it's ignorance or what, or lack of training, But there's definitely a gap there of what doing things the right way and not doing things the right way.
In your mind, what's the consequence to CRRUA's customers of CRRUA not following the rules?
I want to object. I mean, I think one, it calls for speculation. Two, I mean, it's vague, it's ambiguous. What's the consequence? And to the extent that it's any form of technical testimony, I just don't think there's a proper foundation been laid for it.
I think Mr. Torres has already said that, for example, with the arsenic plant offline, and them not paying attention to the pH levels, that untreated water was distributed. To the extent you're seeking another opinion, though, I think you have to lay a foundation.
Okay, so in your experience, in your position, untreated water being distributed to consumers, is that a positive thing or a negative thing for their consumers?
Negative.
Why is that?
Untreated water, because of the arsenic levels they have at their wells. They have high arsenic, no fault of their own. It's just the geography and of where their wells are. So not removing that arsenic to compliant levels under the 10 parts per billion puts their customers at risk of drinking non-compliant water.
Thank you, Mr. Torres. I have no further questions at this time. I do reserve the right to redirect.
Thank you, Mr. Real. Mr. Trujillo?
Madam Hearing Officer, I don't anticipate a long cross-examination. Could we have 5 minutes to confer with the clients?
Sure. Let's just take a short break then.
Thank you.
I'm back at 10. How about that? All right, let's come back from the break. Mr. Trujillo, do you have questions for Mr. Torres?
Yes, may I approach?
Yes.
Thank you.
Mr. Torres,
Yes, sir.
can you please take a look at the document there on the left? That is one of the pleadings in this case. It is the second amended administrative compliance order. I know are you familiar with this document?
Not.
You don't have to be. This is not
Okay.
for your personal knowledge.
Mhm.
And then if you could go ahead and take a look at the other document there that's labeled Exhibit Number 2. It's right there in front of you to the right.
Oh,
There it is. It's a loose document. And that is CRRUA's Exhibit Number 2. This is a term sheet for the civil penalty assessed in this matter. And Mr. Torres, I'm assuming that you don't have any familiarity with that term sheet. Is that correct?
that's correct.
I'm not sure if there's an objection. We're going to submit it into evidence as part of the record in this case. I'm not intending to ask him any questions about the calculation of the penalty. I'm not intending to ask him anything to the effect of, it's a simple question regarding how his testimony relates to the penalty policy. I mean, to the exhibits. That's it.
Yeah, the only objection I'd have is lack of foundation if he does stray into that area, but if it's not, then
Okay, but do you object to the admission of Exhibit 2?
or are you moving to admit exhibit 2?
Yeah, I'm going to move to admit exhibit 2, or I can just ask him questions about it without admitting it into exhibit 2. I mean, I know you're going to call Maria Medina, and that's her document. It's going to get admitted at some point.
Yeah, I don't object to admission.
All right, CRRUA Exhibit 2 is admitted.
Mr. Torres, your testimony on direct, you testified that you conducted an investigation into CRRUA and that during that investigation, you discovered that the arsenic systems were offline. Is that correct?
Specifically to industrial park.
Okay. And so I'd like you to take, this is the term sheet for the civil penalty in this matter, exhibit number 2. And you testified that you issued a notice of violation to CRRUA for failing to notify NMED that the arsenic systems were offline. Is that correct?
No, the NOV that we submitted from the investigation was for the public notice.
For the public notice. Okay, so let's take a look then at the second field, December 12th, 2023. Failure to notify customers of high pH levels and provide customers with appropriate action to take in order to protect themselves against any waterborne hazard. You see that?
Mm-hmm.
So your testimony supports that specific violation, correct?
Madam Munoz, I want to object to foundation as to the document. He already said he's not familiar with the document, but if he rephrases it in some way.
Right, as I heard your question, Mr. Trujillo, it was unclear to me whether you were asking Mr. Torres if it was only his testimony that supported that second violation box, and I don't think he could know that if he wasn't part of this, preparing it.
I'm asking him to read the words on the page, and I read them into the record. Failure to notify. There's a violation. Failure to notify customers of high pH levels and provide customers with appropriate action to take in order to protect themselves against any waterborne hazards. It sounds to me like your testimony supports that specific violation. Would you agree?
Yes, I would agree.
And in the first violation on the same document, it reads, failure to notify NMED that the Industrial Park Arsenic Treatment Plant, the Sunland Park Arsenic Treatment Plant, and the Santa Teresa Community Arsenic Treatment Plant were offline and intentionally bypassed for over a year, allowing untreated water into the distribution system. Sounds to me like your testimony supports that specific violation, correct?
Madam Hearing Officer, he just testified that he only knew about one of the treatment plants, and anything he doesn't have any foundation to testify about what's in this document.
Now we'll rephrase them.
Okay.
So failure to notify, these words on this page, failure to notify NMED that the Industrial Park Arsenic Treatment Plant was offline and intentionally bypassed for over a year, allowing untreated water into the distribution system. It sounds to me like your testimony supports that specific violation on that page, right?
Yes.
Now, if you take a look at the complaint in this case, second amended administrative compliance order, I want you to go to page.
Object to foundation again. He said he wasn't familiar with that document.
This is the complaint this is the complaint. So I'm asking him to refer to the complaint. I'm not asking him if he helped draft it or if he wrote it. I'm going to ask him specific questions of the language on the complaint.
Okay. I'll hold him to him.
Why don't you go to the bottom of page number 3?
Yes.
Paragraph 15.
15?
15. 1-5.
Mm-hmm.
See that? So it says respondent violated 20.7.10.400E NMAC by failing to notify NMED that the Industrial Park Arsenic Treatment Plant, stop there, was offline and intentionally bypassed for over a year, allowing untreated water into the distribution system. You see that?
Yes.
Sounds to me like your testimony supports that specific violation in paragraph 15, correct?
Yes.
And then go to the next page. You see paragraph 16 at the top?
Yes.
And that paragraph states, respondent violated 20.7.10.600C NMEC by failing to notify customers of high pH levels and provide customers with appropriate action to take in order to protect themselves against any waterborne hazards. You see that?
Yes.
Sounds to me like your testimony supports that specific paragraph in this amended administrative compliance order, paragraph 16. Is that correct? Thank you. I have no further questions.
All right. Anything further, Mr. Real? No?
I would ask that Mr. Torres be excused if there's no objection from opposing counsel.
Right. Is there any reason not to excuse
No
Mr.
objection.
Torres? Thank you. Thank you very much,
Thank
Mr.
you.
Mr.
Torres.
Torres.
You're our next witness, Mr. Real.
The New Mexico Environment Department calls Maria Medina.
Hello. Would you state and spell your first and last name, please?
Yes, Maria Medina, MARIA, MEDINA.
Do you swear or affirm to tell the truth?
Yes.
Thank you very much.
Madam Hearing Officer, before we start, can we ask her to get the mic a little bit closer?
Oh, I think it's fixed in
Oh,
that
is it
place,
fixed?
and we don't
Okay,
want to
maybe.
wreck it. Just speak up, please.
Yes, ma'am.
Good morning, Miss Medina.
Good morning.
It appears you're very nervous to be here today.
Yes.
I just need you to tell me the truth, okay? Can you tell us how you are currently employed?
I am an enforcement coordinator for the New Mexico Environment Department
How long have you been in that position?
since 2014,
And how long have you been with the New Mexico Environment Department?
close to 20 years.
Can you describe your career path that led to your position as the enforcement coordinator?
I started as a compliance officer with the Drinking Water Bureau here in Santa Fe, and then I moved into the enforcement coordinator position.
Sorry, you will have to speak up. She said enforcement coordinator.
Madam Hearing Officer, would it help if she sat at the dais with one of the microphones that are closer?
Sorry, I was wondering actually, well, that might make sense because these are movable.
I can really try. I don't want to go up there.
All right. All right. And maybe the other thing, I know the temptation is strong to face Ms. Nixon as though the two of you are in conversation, but it will help if you direct your voice toward the microphone.
Yes, ma'am.
Thank you.
And what division did you work with as the compliance officer?
With the Drinking Water Bureau.
And what are your current duties as the enforcement coordinator?
I draft and issue administrative compliance orders using the EPA's enforcement targeting tool, or ETT, which ranks and prioritizes systems for enforcement. It gives points to violations, and the points depend on the severity of the violation and the length of the violation. And any system that's 11 points or higher is considered a priority system for enforcement.
So once the systems are prioritized, what is your role as the enforcement coordinator?
I look at the ETT list, or enforcement targeting tool list, to see what systems have the highest points. I check the length of the violations. I check the type of violations they have. I check our database. And if any information is needed, I will contact the compliance officer to make sure that everything is valid. And then I start drafting the order.
And do you also calculate civil penalties if appropriate?
Yes, I do.
Are you familiar with the process that the department uses to assess violations and pursue enforcement actions?
Yes, usually the compliance officer issues the violations, and if that system has several violations that add up to 11 points or more, they go on the ETT list, and then that's where I start my process to see if it's appropriate to issue an administrative order with penalties or not penalty.
And when you are issuing an administrative compliance order, what's described in that type of order?
The system's information, the history of the history of violations, the compliance deadlines, the penalties, if any, are in there, and who to contact if the system requests a hearing or a settlement.
Can you please describe your work as the enforcement coordinator with water systems that are chronically non-compliant?
I use the ETT list to track those systems, and I have meetings with my supervisor to let him know that which systems I'm thinking about issuing an order.
In your experience as the enforcement coordinator, has CRRUA been a chronically non-compliant water system?
Yes, they have.
And how do you know that?
Because they've had administrative orders, they've had several violations regarding arsenic MCL and significant deficiencies, and those accrue points, and those go on the HT list.
In the course of your duties, have you written administrative compliance orders against CRRUA?
Yes, I have.
And how many administrative compliance orders?
2, 2016 and 2024.
And take me back just a little bit. When you're preparing the ACO, what information do you receive or review? I'm sorry.
I reviewed the ETT list. I reviewed the violations to make sure they're valid. I check our database. And again, if I need any more information or clarification, I talk to the compliance officer in charge of that system.
Thank you, Ms. Medina. I would like to direct your attention to what has been marked and admitted as evidence in this matter as NMED's Exhibit 6. And can you just remind us for the record what exhibit number 6 is?
Yes, this is the Administrative Compliance Order and Assessment of Civil Penalty.
And when was that ACO and Assessment of Civil Penalty issued?
July 27th of 2016.
And who was that issued against?
Camino Real Regional Utility Authority.
Is this the 2016 Administrative Compliance Order that you drafted?
Yes, it is.
And what violations were identified in that 2016 ACO?
If my memory serves, it was exceedance of the arsenic MCL and failure to provide public notice for exceedance of the arsenic MCL.
Ms. Medina, did you write the order that is the subject of today's hearing as well?
Yes, I did.
And is it fair if I refer to that as the 2024 ACO?
Yes.
How many violations were identified in the 2024 ACO?
5.
Do you recall?
Madam Hearing Officer, can I make clarification? Can I just request clarification? Are we talking about the second amended?
I'll clarify. Thank you. Ms. Medina, did you draft the original Administrative Compliance Order and Assessment of Civil Penalties in this case?
Yes, I did.
Ms. Medina, did you draft the first amended Administrative Compliance Order with civil penalty?
Yes, I did.
And did you also draft the second amended
Sorry. No.
In the original 2024 ACO, you said there were 5 violations identified.
Yes, ma'am.
Do you know what those 5 violations were?
If I remember correctly, failure to notify NMED of bypassing the arsenic treatment plants, failure to provide public notice for the pH issues, failure to correct significant deficiencies for the 2019 sanitary survey, failure to correct significant deficiencies 1 through 4 in the 2023 significant sanitary survey, and exceedance of the arsenic MCL at the Industrial Park Arsenic Treatment Plant.
Did you assess penalties described in the original 2024 ACO?
Yes, I did.
And it's my understanding that the original ACO was then amended in March 2024, correct?
The original, I believe, was issued in February, I believe.
And was it amended in March 2024?
Yes,
And why was the original administrative compliance order amended?
because there was a mistake with one of the violations. The penalty assessed was incorrect.
I would like to direct your attention to what has been marked in that notebook as NMED's Exhibit Number 1. Mr. Trujillo, is there any objection to the admission of NMED's Exhibit 1, which is the penalty policy?
No objection.
Exhibit 1 is admitted.
Thank you, Madam Hearing Officer. Ms. Medina, can you tell us what Exhibit Number 1 is?
This is the New Mexico Environment Department Drinking Water Bureau Enforcement and Penalty Policy.
Is this what you used to calculate the penalties in this case?
Yes, ma'am.
And is this what you used to calculate the penalties against CRRUA?
Yes.
Can you please turn to page number 3 for me? Near the bottom, according to the penalty policy, what's the first step you take when you are calculating civil penalties?
I look at the severity of the violation and to see what their gravity factor is, and that's if it's a minor or a moderate or a major.
And flipping to page 4, I see there's a chart. Can you tell me what that chart demonstrates?
These are some of the examples of what the violations can be, the categories of the violations fall under.
And when you say the categories, that would be the gravity factors.
Yeah, the minor, moderate, and major.
Is the chart on page 4 a complete chart of all the violations that could fall into each category?
No, there are other violations that could fall into these categories or gravity factors.
Is it fair to say then that this chart gives you an example of the types of violations that would fall into each category?
Yes.
Did you assess a gravity factor for each of the 5 violations in the order at issue today?
Yes, I did.
And again, this was for the original and first amended ACO, correct?
Yes.
For the first violation, the failure to notify NMED that the treatment plants were offline and had been intentionally bypassed for over a year, what gravity factor was that assigned?
I believe it was a moderate.
For the second violation, which relates to the failure to notify customers of high pH levels, what was it originally assigned as a gravity factor?
Also as moderate.
After further review and after receiving some more information, was that a correct assignment of the gravity factor for violation 2?
No, it was not.
And what should it have been?
It should have been a minor.
To your knowledge, has that been corrected?
Yes.
Why was that error made?
All I can say is a human error.
Did you intend to punish CRRUA more harshly for that second violation?
Not at all.
Let's move on to the third violation, the failure to correct significant deficiencies from the 2019 sanitary survey. What gravity factor was that assigned?
A moderate.
And for the fourth, the failure to correct significant deficiencies from the 2023 sanitary survey?
A moderate.
And what about the fifth, the exceedances of the arsenic MCL during the first quarter of 2024?
Also moderate.
So for violation 1, 3, 4, and 5, those were all assigned a moderate ranking because of the threat they pose to public health?
Yes.
And after you make the assessment of the gravity factor, what is your next step?
I look at the gravity factor over here with, I look at how long the violations have been out of compliance. I look at the population of the system, and because the system has was out of compliance for a long time, I issued the maximum gravity factor of
on this chart, which is 7 for a population of 10,001 to 50,000.
And just for the record, you're referring to the second chart on page 4 of the penalty policy.
Yes, ma'am.
And so the population that CRRUA serves is between 10,001 and 50,000. Am I hearing you correctly?
Yes.
And for a moderate level 7 penalty, which you assign to violations 1, 3, 4, and 5, that amounts to $420 per day, correct?
That's correct.
And for violation 2, with a corrected factor of minor gravity 3, can you tell us the value of the per day violation?
It's $180.
So after you've examined that chart and determined the value of the per day penalty, what is your next step?
I look at the multi-day component, which is how many days the violation has been outstanding. But if a system has been out of compliance for 250 days or over, we can cap that per day component at 60 days.
You said NMED can cap that at 60 days. Is it required that that penalty be capped at 60 days?
No.
So it's discretionary?
Yes.
How many days did you calculate violation 1 to have occurred for?
202 days.
And was that based on information from the compliance office?
It was from the violation letter that the compliance officer issued.
And for violation 2, how many days was it originally calculated for?
202.
Was that a correct number of days?
It was not.
Was it intentional?
No.
What was the correct number of days?
7 days.
And to your knowledge, has that been corrected?
Yes.
So it's been corrected to 7 days.
Yes.
And so that would be 7 days multiplied by the $180 per day you explained.
That's correct.
And how many days for the third violation?
60 days.
And why did that violation exist for longer than 60 days?
Yes, it did.
And so NMED exercises discretion to cap that penalty.
That's correct.
Is it fair to say then that NMED could have included all of the days that for violation number 3 and not capped it at 60 days?
That's correct.
Do you believe that it would have been a higher penalty calculation if NMED had not capped that penalty at 60 days?
Yes.
How many days did you calculate violation number 4 for?
I believe 44 days.
And how many days for violation number 5?
91 days.
And can you tell me why 91 days?
Because it was for the first quarter of 2024, and in that first quarter had 91 days.
Okay. After you've calculated the per day penalty for each violation, what is your next step?
I add everything up together, and I finish reviewing the administrative order, and then send it over to my supervisor for review.
And I'm noticing on page 5 of exhibit number 1, a paragraph about the good faith reduction or bad faith enhancement. The penalty policy allows NMED to consider those things, correct?
Correct.
Can you describe those two adjustments for us?
Yeah, the good faith, we can include a good faith effort to a system who pretty much polices themselves. If they find a violation, they contact them, NMED themselves, and are trying to resolve the violation. And a bad faith enhancement can also be included up to 50% if the system has a history of non-compliance, has been aware of all the violations, and is not doing really anything to come into compliance with those violations.
Is it required that NMED include either a good faith reduction or a bad faith enhancement to the penalty assessments?
No.
So that's also discretionary.
Yes.
When the original administrative compliance order was issued, what was the total penalty that was assessed for all 5 violations?
I believe it was 251 plus, close to $252,000.
Somewhere between $251,000 and $252,000.
Yes.
If I represented that total number was $251,580, does that sound correct to you?
That's correct.
And did that total include either a good faith reduction or a bad faith enhancement?
No.
Has that total changed to your knowledge?
Yes, it has.
And in what ways has it changed?
It went, the penalty, it was amended because of the error, and it's at 168,000, I believe.
And was that 168,000 with or without considering a good faith reduction or bad faith enhancement?
Without.
And Ms. Medina, did you ever calculate a penalty that included either the reduction or the enhancement?
No.
And in the administrative compliance order, I believe you explained that those typically include instructions about who to reach out to if they request a hearing or settlement, correct?
Correct.
And in the original ACO that was issued to CRRUA, who were they instructed to reach out to for a hearing or settlement discussions?
If I remember correctly, is myself, the bureau chief, or counsel.
Did CRRUA ever reach out to you personally to discuss a hearing or settlement?
No.
And according to the penalty policy, if CRRUA had reached out, there are certain things to be considered, correct?
Yes.
One of the things that the department may consider when a system reaches out is the system's ability to pay. Is that correct?
Yes.
And that comes from the penalty policy?
Yes, it does.
Did you learn that CRRUA was unable to pay for any reason?
No.
Have you become aware of different activities involving CRRUA since you issued that original ACO?
Yes, they have been issued I believe three other notices of violation for exceeding the arsenic MCL, and also for failure to correct significant deficiencies identified during the 2023 sanitary survey.
Are you aware, other than those notices of violation, do you know when those were issued?
No, I don't.
Okay. You did not issue those?
No.
And are you aware of any other arsenic exceedances for which notices of violation were not issued?
I believe there was a single sample in 2025, and there was also some special samples that the system collected.
Okay.
That exceeded the MCL.
But those were not part of your role in enforcement?
No.
So after the ACO, the original ACO was issued, there were subsequent violations in 2024, but not in 25.
That's correct.
Okay. I want to direct your attention now to page 5 of the penalty policy. And near the bottom of page 5, this states the DWB must recalculate the civil penalty whenever it obtains new information affecting the basis for the civil penalty. Did I read that correctly?
Yes.
And to your knowledge, did the Drinking Water Bureau recalculate the penalty based on new information that it had received?
Yes.
Thank you, Ms. Medina. I have no further questions at this time, but would like to reserve the opportunity for redirect examination.
Thank you, Ms. Nixon. Mr. Trujillo or Ms. Carey?
Can we just consult for one minute?
All right.
Ms. Medina, are you the statewide enforcement coordinator?
Yes, I am.
Are there any other enforcement coordinators?
Not that I know of.
You're it. You're
I'm not sure of the other departments if they have someone like me as an enforcement coordinator. I believe they do enforcement, but I don't know if it's a specific role. So I don't know.
for Drinking Water Bureau. In other words, you're the
For
statewide enforcement coordinator.
Yes.
I believe there's an exhibit in front of you that's labeled Exhibit 2. You see it?
Yes.
This is the term sheet.
Yes.
And just for the record, you're referring to CRRUA's Exhibit 2.
I'm sorry, CRRUA's Exhibit 2. And this, did you prepare this document?
No, I did not, but I did help my bureau chief prepare it.
Okay, so who prepared it then?
My bureau chief,
And can you identify the bureau chief?
Joe Martinez.
Okay. On the back, on the last page, it states that you are the case lead, along with the NMED Assistant General Counsel. Do you see that?
Yes.
What does the case lead mean?
To tell you the truth, I'm not sure. This is something new that this administration has implemented. And from what I understand is I'm the one who writes the orders. That's what I understand as a case lead, but I'm not sure.
Okay, so you've never been the case lead for other cases, or is this the only case lead that you're currently operating on?
We started with this administration doing this type of thing, calling it a case lead. We've never done that before.
And when was that started?
In 24, I believe. I'm not sure.
Okay. And so there's no like position description for the case lead, or there's no like, sort of written protocols for what the case lead does?
Not that I know of.
So did you, if you didn't prepare this document, did you review it and approve it, or what's the process for creating this document?
To tell you the truth, I don't remember. This has been such a long time ago, but I know that I conferred with my bureau chief and he put it together. I don't remember seeing it, but I don't not remember seeing it either.
Okay. You talked about the ETT list. Can you tell us how many entities are on the ETT list, if you know?
I don't know.
Could you estimate?
Probably.
Objection, Your Honor. That calls for speculation. She already said she doesn't know how many are on the ETT list.
She may have an estimate, even if she doesn't know the exact.
I can ask a
number.
more specific question. More than 5?
Yes.
More than 10?
Yes.
More than 20?
Yes.
More than 30?
Yes.
More than 40?
Yes.
More than 50?
I think so.
So it's maybe 50. More than 60?
I would think so. Yeah.
More than 100?
That I'm not sure.
Okay. Less than 100, but more than 60.
I believe so. I can't be sure.
We're not going to hold you to an exact number, just an estimate. So, you know.
She's answered this question.
I think she has given you her best answer.
Thank you. And you stated that when you get a violation, or when you refer, do they refer cases to you? How does that work? How does that process work? Like you would actually have, for example, let's take the case of CRRUA, right? How does the administrative compliance order process begin for you?
I look at the ETT list and the systems are on there. They have points on there. I review to see the gravity of the violations, how long have they been out of compliance, and then I look at our database, I review the violation letters, and if I have any questions, I contact the compliance officer.
I want to take a step back before that. Before you actually, how do you become aware to know to look to the ETT list? Like, what is there a form that's given to you? Say, we got a violation here, or like, what? How do you become aware of that?
I run the ETT list every week.
But what I mean is how do you look at the ETT list every week to see if there's anyone in violation that you can prepare a compliance order for?
Yeah.
Okay, so in other words, part of your job duties then is to regularly check the ETT list on a weekly basis to determine if there are any non-compliant systems that need to have a compliance order prepared by you.
Yes, but I run it weekly. I don't necessarily look at it weekly.
And so how does that show up on the ETT list? If you you pull it up on your computer?
It's a database, yes.
And is it like a red flag system, that some sort of system that has a NOV rises to the top and that flags it for you? Is it something like that? How does that work?
The NOVs get assigned points. So the system would be, X system, and it has 75 points. So that's how they're ranked.
Okay. So is it accurate then to say that on some certain date you went to the ETT list and you saw CRRUA had been assigned a certain number of points for NOVs, and that triggered you? Triggered you. It set off your process for preparing a compliance order because the number of points rose to that level?
You could say that, yes.
Is that how it happened?
It happens, like that's what I look at, but also there are other factors, a system compliance officer or a supervisor say, hey, the system has been receiving a lot of violations, and so it's going to come up. I start looking for those when they rise up to that level.
Do you remember the day when you saw CRRUA there and you said, I'm going to start preparing this?
No.
And so when you see, can you describe to us what you see when you see the ETT list with CRRUA on, or any non-compliant system on there? Like, what are the fields? Is it like a spreadsheet?
It is a spreadsheet, and it has the violations listed and the points assigned to it.
Okay, so you saw, if you take a look at exhibit number 2.
Again, this is CRRUA's exhibit number 2.
And CRRUA's exhibit number 2. These are the violations that you saw when you pulled up the ETT list?
Yes.
Okay. So you saw December 12th, 2023 that an NOV had been issued regarding failure to notify NMED?
Yes.
And then you saw December 12th, 2023 failure to notify customers of high pH levels.
Yes.
And you saw March 16, 2020, failure to correct significant deficiencies.
Yes.
And then you saw January 17th, 2024, failure to correct significant deficiencies 1 through 4.
Yes.
And you saw January 17th, 2024, failure to the arsenic MCL.
Yes.
And going back to number 1, you saw that failure to notify NMED that the industrial park arsenic treatment plant was offline and intentionally bypassed.
No, I don't see the specific, I see the code.
Okay, what is the code?
It's, if I remember, is the NEMAC, the 20.7.10.400, I believe. This is a brand new one for me, so I think it was that. I don't remember.
So is there any supporting documentation in the ETT list that gives you information on the specific violations?
Yes, it says failure to report, and then I start digging into it, looking at the violation letters.
So then you pull up, do you request those from the local offices or do they send them to you automatically? How does that work?
I can go to the electronic central file.
There's like a database.
Yes.
And so you can go in and you can, so do you usually do that first or will you look at prior history?
I do both.
Okay. And so you'll go to the notice of the violations and you'll see the specifics of the violations.
Yes.
And is that where the language would come from for like the specific violations here?
Yes.
Objective Foundation, Your Honor. She's already testified she didn't write this document.
She said that she helped the bureau chief with it.
So does that inform sort of like the language? Like, do you look at the supporting documentation from the local compliance office that issued the NOV, and then that'll sort of form the basis for like, the term sheet?
Yes.
And so you and then I think you testified that you'll then go to, I'm sorry, actually, I want to take a step back. Is the ETT list, is this something that just exists in general that is, or is it like an interactive list that gets updated regularly?
It's interactive. It gets updated.
Like once you're on the ETT list, can you ever get off?
Yes.
How do you get off?
By resolving all the violations.
So hypothetically speaking, if a water system resolves all its violations, then it will be removed from the ETT list?
That's correct.
So the 60 to the number of entities that are on the ETT list, those are active compliance orders.
No, those are just systems that are priority systems for enforcement.
Okay, so to help me understand that, they're not inactive compliance order, they're priority systems for enforcement. Does that mean that they're like, how do they, like, what's the criteria for placing them on the ETT list?
Objective Foundation, she doesn't create the ETT list.
Well, if
do you know how it's created?
Right, if you don't know, you can say I don't know.
I don't know.
Do you know how, what, do you know who puts an entity on the ETT list?
It's EPA system. So the violations get points, and the points, once the system accrues 11 points, it gets put on the ETT list.
So if a local compliance office issues a notice of violation, they'll enter it into the ETT system?
I'm sorry, say that again?
If a local compliance office issues an NOV, do you know if they put that into the ETT system?
No, they don't put anything in the ETT list.
Do you know how the violations are entered into the ETT system to assign them points?
No.
Okay. So going back to CRRUA, when you saw the ETT list, you see CRRUA's on there, say, I need to start working on this case, right? And you look at the notices of violations so that you can start to determine the length and the severity of them, correct?
Correct.
And at that point, what point do you look for like the previous history? Because I think you testified that I was like, well, I'm going to check the type of violations they have. That sounded to me like it was looking at previous compliance. Is that what that is?
Yes, it's the violations that are there that are still outstanding.
So it doesn't have anything to do with when you said that I check the type of violations they have, that didn't mean that you go back into a system to see if there is actually old violations that have been resolved.
I can see that in the database.
You can see that.
Yes.
And do you look at that?
Yes, I look at that.
Okay. And so what do you do with that?
I just
That
know
information.
I just know that it's a history of non-compliance.
Okay.
Even though they resolved it, there still is the same violation over and over.
Got it. Okay. So you stated that you calculate the penalties, you actually assign the dollar values?
Yes.
Did you assign the dollar values in Exhibit 2?
Yes.
Okay. And so you actually inputted the duration, 1 year, 7 days, 4 years, 40 days, 1 calendar quarter.
Yes.
You determined that.
Trying to Yes.
Okay. So you input this into it, and then you calculated so you selected the initial penalty, then you added a multiple day component,
Yes.
and then you came up with a total.
That's correct.
And that total on Exhibit 2 was $251,580.
Yes.
And prior to doing that calculation, you had seen CRRUA on the ETT list. You had reviewed the notices of violation, and you had reviewed CRRUA's history and had seen that they had previous violations of a similar nature, correct?
Correct.
And I think as you testified, that at the time that you did this, you did not add a good faith reduction, right?
That's correct.
And you did not add a bad faith enhancement.
That's correct.
Even though you knew that CRRUA's history was a 2016 administrative compliance order, which you prepared, right?
Correct.
Okay. And you then drafted a compliance order
Yes.
in this case.
Yes.
And once you draft that, who do you submit that to?
To my supervisor,
And who's your supervisor?
Martin Torres.
Martin Torres?
Yes.
The Martin Torres that testified earlier?
Yes, he's my supervisor.
So you submitted that. You submitted the 2024 administrative compliance order to Martin Torres?
Yes, for review.
And Mr. Torres then, what what does he typically do when you provide him with administrative compliance orders?
Object to foundation.
To your knowledge, if you know.
He reviews it.
And does he respond back to you?
Yes, if there's need changes.
Does he usually do that in writing?
Yes,
And he will review it and make recommendations for revisions or edits and send them back to you.
yes,
And Martin Torres is based in Las Cruces.
yes,
And so you do this virtually or electronically.
correct.
Okay. And so what types of revisions will he usually make on like grammar,
Grammar, yes,
like catch mistakes?
yes.
You missed does he ever substantively look for, well, I think that this should not have been a moderate violation, it should have been a major,
Sometimes yes,
this should have been a minor?
yes,
So you drafted the administrative compliance order in this case, which was filed on this amended administrative compliance order, which was filed on March 1st, 2024. You drafted that and sent it to Martin Torres. And did he respond to you?
don't remember sending that one because it was just a minor error on that one, on the first amended.
So the process is not for him to approve them before it goes to the next step,
Is for him to review it,
but not to approve it.
not to approve it that it's ready to go. It's just ready to go to the next step.
And what is the next step?
It goes to our bureau chief, Joe
And-
Martinez.
Okay. And then what happens? What's the process after it goes to Mr. Martinez, if you know?
Once he's reviewed it, and he's okay with it, it goes up to the division director for signature.
Okay. One second. I just would like a point of clarification. Did you testify that the penalty amount changed between the original ACO that you issued on February 2nd, 2024, and the first amended ACO issued on March 1st, 2024? We weren't sure if you said that the penalty changed or if it was just clarification of like a typo.
I don't believe the March one had the correction of the penalty. It was just a typo.
Like correcting a letter or something.
Yes.
So you drafted the first amended administrative compliance order, and you used the civil penalty that you calculated in the term sheet, and you put it into that amended administrative compliance order, right?
Object to form, Your Honor. She has testified repeatedly that she did not draft the term sheet, and he continues to ask her questions about her drafting the term sheet.
Right. She only assisted in the preparation. She assisted the bureau chief in the preparation of the terms.
I believe I asked that she drafted the administrative compliance order and she used the penalty that she calculated in the term sheet.
You said in the term sheet that she drafted.
Okay.
I apologize. I
All right. I'm sorry. We're back after a short break prompted by some technical difficulties here. Mr. Trujillo, sorry for the interruption.
No problem.
Please go ahead.
You've testified that you drafted the 2016 Administrative Compliance Order, correct?
Yes,
So when you saw CRRUA on the ETT list in 2024, more or less, did you remember that name?
yes.
And you remembered that you had drafted an Administrative Compliance Order 8 years prior?
No, after, it was after, but I have so many systems that I look at.
So, but you did remember the name CRRUA, and did you look up the Administrative Compliance Order before you calculated the penalty?
Yes, I have to. I have to make sure I have everything in place.
And what do you mean when you say I have to have everything in place? Like,
Make
what is
sure that,
everything?
was that order terminated? No. Is it still open? What is going on with that order? So I need to make sure I'm not doing something wrong.
And do you look at the substance of the order?
Yes,
And do you, just peruse it, or do you actually read it carefully?
I peruse it.
Okay. So you don't really identify what the previous violations may have been in that compliance order. You're just like, there's a compliance order. All right.
No, I look at the violations. There is a section that says violations, so I know what the violations are, so I can go straight to that section.
And did you do that in this case?
I believe so, I did.
You testified that you didn't draft the second amended ACO. Do you know who did?
I actually don't.
Were you given any input? Were you given the opportunity to have input into the second amended administrative compliance order?
If I remember correctly, I believe I did.
You were given the opportunity.
I believe so. I don't remember.
So what do you remember about the second amended administrative compliance order discussions?
I actually don't remember.
Do you know who they were with?
I don't, since it really didn't involve me.
I'm sorry?
It didn't really involve me because I wasn't going to draft it.
So you remember you were given the opportunity, but you don't remember providing any feedback on it.
I think I don't remember.
And you don't remember who you had discussions with?
With one of our attorneys.
I don't want you to tell me what you said with them, but you said you had conversations with one of your attorneys. Is that the extent of the discussions regarding the second amended administrative compliance order?
Yes.
Was it multiple times that you had conversations?
No.
One time?
Yes.
Can you take a look at CRRUA's exhibit number 2 again, please? I know you mentioned that violation number 2 was downgraded from moderate to minor, but I didn't get a sense of when that took place. You recall when? Was it prior to this calculation? You caught it before you made the calculation that's in term sheet CRRUA's exhibit 2?
Object to form. She's already testified that she didn't make that change with the first amended ACO.
Right. She said that the first CO, the original CO, was February 24. The change was made in March 2024. That's what I remember.
I thought she testified that the calculation in this term sheet, the number did not change into the first amended administrative compliance order. Those numbers stayed the same.
That's correct. So your question has been asked and answered. It was not changed before the amended ACO, which tells you the answer to your question.
When was it changed?
What was changed?
You stated that you testified that the violation number 2 was changed from a moderate violation to a minor violation, that would have a corresponding reduction in a dollar amount, right?
Correct.
And if it didn't happen before the first amended administrative compliance order was filed, when did it happen?
I guess I'm confused with the first amended was in March 2024. The only change on that one was grammar.
Mm-hmm. So when did, if as of March of 2024, CRRUA was assessed a moderate violation for violation number 2, and today you testified that that was downgraded to a minor, when did that downgrade take place?
I don't know.
No idea.
No.
Any time between March and today?
Sometime, yeah. I
Did
don't
it
know
happen
when
yesterday?
No, it didn't happen yesterday.
Last month?
I don't recall.
And how was that error corrected? Is there a document that corrected it? Is there some notation somewhere that there is a correction?
I believe that was the I didn't draft it, so I don't know when the reduction of the penalties was done. I don't know when that was drafted or anything like that. I didn't have anything to do with it.
So you didn't actually reduce the penalty.
No.
You testified that that was corrected, but you didn't correct it.
No.
And you don't know who corrected it.
No.
And do you know if a new term sheet was actually generated to reflect that?
I don't know.
And so I think you testified that there was $168,000 penalty currently.
I believe so, yes.
Or what was the substance of your testimony regarding the $168,000 penalty?
That's the corrected penalty.
You didn't correct the penalty.
No.
What's your basis for knowing that the penalty was corrected?
I was aware that that was the amount.
I'm sorry.
I was aware that that was the amount. I didn't have it in writing. I just, in meetings, I believe that's how it was mentioned.
So there were meetings that took place that the discussion was, we made a mistake. We charged them with a moderate. We're going to reduce it to a minor, and we're going to reduce the penalty correspondingly.
I'm going to object to that question to the extent it seeks attorney-client communication. Ms. Medina has testified that the extent of her communication regarding the recalculation was communication with her attorney. So I believe you're treading into the territory of protected attorney-client communication.
Okay, I don't hear him. Hold on. I don't hear him asking for the actual communication of a meeting with the attorney. I think he's just trying to establish that the information was conveyed in a meeting, which may or may not have been with an attorney.
I don't recall I just remember that it was $160-something thousand.
Were there any other corrections that were made to your knowledge that resulted in the penalty that you initially calculated being reduced from 251 odd number to 168?
Not to my knowledge.
So it was, to your understanding, it was just the change from the moderate to a minor.
I believe so.
So you take a look at page 2 of the term sheet. I'm going under penalty scenarios. The second sentence, I'm going to read it to you. And I want to know if you made this calculation. For the first two violations noted above, Drinking Water Bureau used 202 days, multiplied by the highest penalty amount for a moderate violation, 420, totaling 169,680. Do you see that?
Yes.
Did you make that calculation? Did you add up those numbers that were placed onto that into CRRUA's Exhibit 2?
The original violation calculations I did.
Yeah, these numbers, these actual numbers.
I think these are the original. I didn't draft this,
I know.
so I don't.
But you testified that you calculated the initial penalty.
Yes.
Okay. And so this is the initial penalty?
I believe so.
This is the initial penalty in the administrative compliance order that you drafted, right?
Yes, because it was 202 days for each.
And so if you look at page 1, you'll see that under duration for violation number 2, it says 7 days. But on page 2, it shows that the Drinking Water Bureau used 202 days for the first two violations, right?
That's correct.
So was that ever corrected? A violation that was listed as a duration of 7 days was actually calculated at 202 days. Is that right?
Right.
Is that a mistake?
Yes.
Was that mistake corrected?
So
I'm
what
going to object to this being asked and answered. On direct examination, Ms. Medina did testify that she corrected both the gravity factor and the number of days.
I remember that she said that.
I didn't understand that was the, so what you're saying is that your corrections went to gravity from moderate to minor, and I'm sorry, the length, did you say length?
The number of days.
The number of days, I'm sorry. So you already said that you reduced the number of days correspondingly.
Yes.
And when you did that, who did you communicate that to?
It was the conversation with my bureau chief when this was being drafted. We realized that there was a mistake that I did as a human. Unfortunately, I make mistakes, and I put it as 202 days when it should have been 7 days.
I make mistakes today. We all make mistakes. How did it come to your attention that you had made a mistake?
I'm not positive. I believe it was CRRUA who brought it up. I'm not sure. I'm not sure who brought it up.
Can you please take a look at NMED's Exhibit 1? The page 5, top of page 5. I believe you testified that you were required to, actually, I'm going to go backward. How often through the course of your position do you calculate civil penalties against drinking water systems?
I can't give you a number. I don't know.
Is it one of your common duties? Is it something you do once a year?
Yes, it's common duty.
Once a week? Once a month?
It depends.
On the flow of the violations. But how many were in 2025, September 4th? How many do you think you've done in the past year?
I believe I have about 14, 15.
You've calculated 14 or 15 civil penalties.
Yes.
And when you calculate the civil penalties, you're required to look into whether or not they have acted in good faith or bad faith.
I'm not required, or I guess we can, according to our policy, we can
You can,
look into it.
you don't
I
have to.
don't. No,
You don't normally.
no.
Normally, you just go by the length and severity, and that's it.
Yes.
And then you submit it on for
Yes.
approval. And once they approve it, they come back to you and say, go ahead and draft up the order.
Yes.
In other words, evaluating for good or bad faith is not something that you have ever done.
Objective form, that was not her testimony.
Have you ever done it?
No.
And so when the third at the top of page 1, I have a patch at the top of page 5, subsection 3 of the penalty policy, where it says adjustment for good or bad faith. You see that?
Yes.
And it says evaluate whether the violator acted in good or bad faith. What you're saying is that your interpretation is that you can or can't do that. Depends. You don't have to.
When I was trained, they never trained me to do this.
And do you know who trained you?
It was Andy Edmondson.
And how long ago was that?
Since 2014.
2014. So since 2014, it hasn't been your standard practice.
That's correct.
And so I'd like you to look at the subsection below, which says number 4, calculate penalty per violation. This appears to be sort of like a mathematical sort of calculation, right? It says calculate penalty per violation, matrix penalty. What's the matrix penalty?
It's over here on page 4.
Is that the severity?
Yes, severity, the gravity, the multiple day component, that's the matrix.
That's major, minor, moderate.
Yes, plus the rest.
Matrix penalty is major, minor, moderate. Then multiple day component would be length.
Yeah, how long the violation has been outstanding.
So this says that what you should do is you calculate the penalty as you matrix penalty, you add it to the multiple day component to get to a subtotal, right?
Correct.
Then it says you multiply the adjustment for good or bad faith plus or minus 0 to 50%. Do you see that?
Yes.
So you're saying that you don't do that?
No, I've never done it.
Okay. And so you didn't do it in CRRUA's
No.
civil penalty. So even though you've never done an actual adjustment for good or bad faith, you do look at the history of the violators, right?
Yes.
So in that regard, you do look at that history. And
Asked and answered several times.
let me finish my question. You do look at that history, and you also will look to see if they've discovered the violation, promptly reported it, and making an effort to resolve the violation.
I guess so.
So your standard practice is then not to apply a bad faith enhancement or a good faith reduction, but you will actually look to see if any of those elements are there.
I don't know if I exactly look. I just look at the history of the violations
Just the history of the violations.
and review the violations and the ETT list.
But what if an entity reported the violation? You wouldn't look at that?
I would if they reported it.
But what if they were making an effort to resolve the violation? You wouldn't look at that?
I would, but for the most part, if they're on the ETT list, they're not looking to resolve or report themselves.
I get it. What if they discovered it? You wouldn't look to that?
How would I know that they discovered it?
Because they would have promptly reported it.
I would definitely look at it.
When you're looking at the past history, how do you interpret the previously warned and the history of noncompliance? Are those kind of the same for you?
Okay, can you repeat the question?
Sure. In subsection 3, it says that in contrast, a bad faith enhancement of up to 50% may be applied if the violator had been previously warned, has a history of noncompliance, knew or should have known that the conduct violated the law, or is not taking action to resolve the violation. Now, you've clearly testified that you do look at the history of noncompliance, and you looked at CRRUA's history of noncompliance before you calculated the civil penalty. What do you do with the language of has previously been warned? Do you think that's the same as a history of noncompliance, or is that different?
It's the violation letters.
So previously warned, if an entity had a violation letter, they have both been previously warned and a history of noncompliance.
That's correct.
In your mind?
In my mind, yes.
I'm sorry. Let me just. You take a look at the last page of the penalty policy, NMED's exhibit number 1.
Mr. Trujillo, just for the record, are you talking about the last page with text or the blank page at the very end?
Well, the penalty policy that you provided does not have that date of signature on it. Oh, no, there it is. Yes, I'm sorry. The last page of text, page 8. I was looking at the very end. There's 9 pages in the PDF. Do you see that date? 12/10/2010 on page 8?
At the bottom?
Yes. Oh, and actually it's at the top of my page 8.
Yes.
So you testified that you haven't been doing term sheets for very long, right?
Correct.
And so if this penalty was passed in 2010, since you've been with NMED calculating penalties, how have you been doing it if you haven't been doing term sheets?
We have our own internal term sheet, and previous administrations also were, it was more of a compliance enforcement kind of help. So we had different penalties.
So you would have like an internal term sheet that you wouldn't share with anyone else?
It wasn't really a term sheet. It was simple math. So, and in the order it said, it was violation 1, 2 to 3, and it's the number of it was like $3,000. So you knew exactly the math. So I guess that was our term sheet, the exact the ACO.
In other words, it was just like type in the numbers or add them up on a piece of paper and then tear it off and put it in the file type thing.
Well, not like that, but it was in the order. So everything is in the order.
In other words, you would calculate it separately and then you would just put those numbers into the order.
Yeah, and it says in the order.
Do you recall how you calculated the penalty in the 2016 administrative compliance order?
Yes.
How did you do that?
It was $1,000 per violation, and there were 2 violations. That was simple math.
I'm sorry if I'm trying to remember the testimony. And so I'm sure Ms. Nixon will correct me if I get it wrong. But I'm trying to understand again so I can ask a question about the last time that you calculated the penalty in this matter. When was the last time? Was it the March 1, 2024 civil penalty? Was that the last time, or did you personally recalculate the civil penalty down to 168?
This has been asked and answered. She did not. She has testified several times that she did not recalculate the civil penalty.
That's my memory as
Yes,
well.
there's a lot to remember. I'm trying to understand. Like, so the last penalty that you calculated was the penalty in the administrative compliance order that you drafted. That was the last penalty.
Yes.
Because you testified about 3 other NOVs and significant deficiencies, or CRRUA not complying with some significant deficiencies in the sanitary survey, right?
Correct.
So what part did that play in the calculation of your penalty?
Not those violations were after I drafted my order.
So what role did those play in the updated penalty?
I don't know.
Do you know if they play a role?
I don't
She
know.
just answered that question.
I'm asking if she knows.
She just said she
Right.
doesn't know.
She said she doesn't know. So you don't know
No,
if those.
exactly.
We need to speak one at a time.
So that means that the second amended administrative compliance order in this case, there's a specific penalty in it. You don't know how that was calculated.
Asked and answered, Mr. Trujillo.
That's right. You need to move on. You have already elicited that testimony from her.
More than once.
And in regards to the test results, I believe that Ms. Nixon asked you about the test results for April 23rd, 2025 and May 6th, 2025, and you testified that those are not part of your role in enforcement, right? Why are they not part of your role in enforcement?
I don't know what those tests are. I don't know April 26th. I don't know dates.
You don't know anything about any test results from
I don't know dates. If you're talking about special samples,
what do you consider a special sample?
something that's out that CRRUA collected.
Okay, like a voluntary, we'd call them voluntary samples. So if it has anything to do with the voluntary sample, you don't see it?
No, I don't see those at all
And so why don't you see it?
because they're special samples. They're not compliant samples.
Does CRRUA send you compliance samples?
No, that has nothing to do with me. That's a compliance officer.
Thank you. No further questions.
All right, thank you, Mr. Trujillo. Ms. Nixon, anything further?
Yes, Madam Hearing Officer. And just for the record, I know we're getting close to lunch. I hope we'll be done by noon. Ms. Medina, I have just a few more questions for you. After you have reviewed the ETT, and before you start drafting the administrative compliance order, do you typically discuss your intention to draft an ACO with the bureau chief or anyone else in your hierarchy?
Yes, I talked to my supervisor, let him know the updates of the systems that I'm considering enforcement.
Do you also explain the reasons that you're considering enforcement?
Yes.
So it's not a decision that you make unilaterally based on your sole review?
No.
I want to direct your attention back to CRRUA Exhibit 2. And this is the exhibit that Mr. Trujillo continued to reference during his cross-examination. And did you use CRRUA's Exhibit number 2, the penalty term sheet, to draft the original administrative compliance order?
No, I did not use this term sheet.
And can you just remind us for the record the date that the original administrative compliance order was drafted and filed?
I believe it was in February. I don't know the exact date.
If I represented to you that the documents in this matter confirm it was filed on February 2nd, does that sound right?
Yes.
And can you tell us what the date on CRRUA's Exhibit number 2 is?
February 9th, 2024.
So that was drafted after the original ACO was filed?
That's correct.
Did you use the term sheet to draft the first amended that was filed on March 1st?
No.
Is it fair to say that you learned about the error in the calculations on violation number 2 sometime after that term sheet was drafted?
Yes.
And Ms. Medina, I believe you testified that in the original ACO and the first amended ACO, you provided some instructions to CRRUA about who to contact for a hearing and or settlement negotiations, correct?
Correct.
And can you remind us who those people were?
Myself, the bureau chief, or counsel.
And at no time were you contacted about any information relevant to settlement discussions?
No.
There was a lot of discussion with Mr. Trujillo about your consideration of various factors that are identified for the good faith reduction or the bad faith enhancement. Do you recall that?
Yes.
And one of the factors for a good faith reduction is whether the water system reported the violation, correct?
Correct.
Did CRRUA report any of the 5 violations identified in your ACO?
No.
And do you know, since it wasn't reported to you, if CRRUA discovered any of those violations on its own?
From what I understand, they did discover it on their own.
But they didn't report it to you or to NMED.
Not that no.
The good or bad faith reductions and enhancements, they're not your standard practice, but does each water system exist within its own context and have its own history?
Yes.
And would you agree that these considerations of the good faith enhancement or good faith reduction or the bad faith enhancement are intended to address those individual circumstances of a water system?
Yes, I believe so.
Thank you, Ms. Medina. I have no further questions.
Thank you. Any reason not to excuse Ms. Medina? Thank you very much, Ms. Medina. Your excuse. We managed to get reasonably close to the lunch hour. It's 11:40. You don't have other witnesses at this point, Mr. Rayon? Oh, you do. Oh, the bureau chief. Oh,
Yeah, the bureau chief.
And Madam Hearing Officer, his testimony will take longer than 20 minutes.
sure. Is it useful to take off that first little bit of it or not? I don't feel strongly either way.
Madam Hearing Officer, we think it would be a more effective use of our time and allow for the best presentation of Mr. Martinez's testimony if we did it all collectively after lunch.
All right, that's fine. Let's come back at 12:45 then, and we'll just pick up where we're leaving off right here.
Thank you.
Thank you.
A comment at one.
Well, so I looked at the order again, actually just now, and it doesn't say that the 1 o'clock public comment is both days. I can certainly see if, well, Luis, has anyone contacted you? No. All right. We may have seen the public comment that we're going to see, but Luis, if someone does reach out, let us know. Let us know.
Okay.
All right. We'll see you in an hour. Lunch break. Let me ask, Luis, did anyone reach out to you about the possibility of offering public comment at 1 p.m.?
No.
Do you see anyone online whom you don't recognize as being affiliated with one of the parties?
Yes, we have quite a few on the platform that I do not recognize.
So if they can hear me though, right?
Yes, absolutely.
Okay. So let me just ask if there is anyone on the platform. There's no one in the room not affiliated with one of the parties, but let me ask if anyone on the platform has joined us in the hopes of offering public comment at 1 p.m. Please reach out to Luis Lopez by raising your hand, your virtual hand, or putting something in the chat. All right. Thank you, Mr. Lopez.
You bet.
No one has reached out. So let's proceed with what we were doing. And let's see, are you Mr. Martinez? You are. All right. If you would state and spell your first and last name, please.
Sure. My name is Joe Martinez, Joemartinez.
Thank you. And do you swear or affirm to tell the truth?
Yes.
Thank you very much. Mr. Real and Ms. Nixon.
Thank you, Madam Hearing Officer. Good afternoon, Mr. Martinez. To start, can you tell us how you are currently employed?
Sure. I'm currently employed as the Bureau Chief of the New Mexico Environment Department's Drinking Water Bureau.
And how long have you been in that position?
Since about 2019, so approximately 6 years.
And how long in total have you been with NMED?
I've been with the department since 2010, so just a little over 15 years.
Mr. Martinez, can you describe your career path with the New Mexico Environment Department that led to your position as the Bureau Chief?
Sure. It's a pretty long path. Immediately out of college, I got a position with the Texas Commission on Environmental Quality in Fort Worth, Texas, where I worked as a drinking water field inspector for them for almost 10 years. I oversaw compliance for large municipal water systems like the city of Dallas and Arlington. I decided to move back home to New Mexico in 2010. I was able to get a position with the New Mexico Environment Department's Drinking Water Bureau as a field inspector at that time. From there, I moved into a supervisory role. Eventually, that led to me becoming the compliance and enforcement group manager, the PWSS manager, and currently now am employed as the bureau chief.
And what are your main job duties and responsibilities as the bureau chief?
They're pretty wide ranging. I have to do everything from leading the bureau of approximately 40 individuals that we or staff people that we have. Prior to July 1st, that number was closer to 60 people. As of July 1st, the department moved our compliance and enforcement sections over into a new division. So that left our bureau as a more of a technical assistance bureau. But as far as my job duties, I oversee everything from ensuring that we have funding through grants. I'm responsible for budgeting. I'm responsible for ensuring that we have staff to essentially meet the mission of our bureau and pretty much everything in between.
And what is the mission of your bureau?
The mission of the bureau is to ensure that all New Mexicans have a safe and a reliable supply of drinking water.
Mr. Martinez, you mentioned a split on July 1st. Was that July 1st, 2025?
Correct.
And did I hear you correctly that meant the enforcement portion of your bureau split off into its own separate division?
Correct. Our compliance and enforcement group within the bureau split off into a new division within the department that is called the Compliance and Enforcement Division. It was set up to essentially ensure that there was consistency across all programs in our compliance and enforcement work within the department.
But prior to July 1st of this year, your bureau did participate in those enforcement and compliance efforts.
That is correct.
And how did your bureau ensure compliance with the Safe Drinking Water Act and the New Mexico Drinking Water Regulations?
We ensure compliance through a variety of ways. We have a group that goes out and collects routine compliance samples from water systems. So we take that data and we verify that the drinking water quality meets the standards of the Safe Drinking Water Act and the New Mexico Drinking Water Regulations. Another part of our program would go out and do compliance inspections. Those are called sanitary surveys that are done anywhere between 3 and 5 years, depending on the type of water system. We have an enforcement section that we will utilize to compel compliance when a water system fails to come into compliance on their own.
So from that testimony, whose responsibility is it for the water system to come into compliance?
According to the regulations, the ultimate responsibility for compliance lies with each individual public water system.
Are those individual public water systems also responsible for staying in compliance?
Absolutely.
And you mentioned part of the role that your bureau played in compliance was taking samples. How do samples contribute to regulation compliance?
I mean, essentially compliance samples are the foundation for determining the compliance with water quality standards. So our teams go out and collect samples from water systems based on the sample schedules that are required by the Safe Drinking Water Act. Once those results come into us, we have another team, which is our compliance team, that would review those sample results. And if a water system exceeded a standard for a maximum contaminant level, then we would issue a violation for that issue.
So the samples tell you whether a system is in compliance or not.
That is one of the ways that we know that whether or not they're in compliance.
How long does it typically take for NMED to get the results from its sample?
There's a lot of different types of samples. So we can get results anywhere from a couple of days after the sample has been collected to several months after the sample, sometimes as long as 6 to 8 months after the samples have been collected.
Mr. Martinez, you're familiar with CRRUA, correct?
Correct.
When did you first come into contact in your work with the New Mexico Environment Department?
I don't recall the exact date, but I do recall that I came into contact with the CRRUA water system around 2016 when I was the compliance and enforcement manager. At that time, we were developing an administrative compliance order that was eventually issued to CRRUA.
And you said the year of that compliance order was 2016?
I believe it was 2016.
Do you recall what the violations were in that 2016 compliance order?
I don't recall all of the violations. What I do recall is that they had violations for exceeding the arsenic MCL. And if I remember correctly, they also had violations for failing to provide public notice to their customers.
And the identification of the exceedance of the arsenic MCL, that would have been based on compliance sampling.
Correct.
To your knowledge, did CRRUA timely come into compliance with the 2016 compliance order?
No, they did not.
Isn't it true that complete compliance with the 2016 administrative compliance order was not completed until 2023?
Objection. Leading.
Is it? Oh, she just asked, is it true?
Isn't it true?
Oh, okay.
Mr. Martinez,
Just rephrase.
what year did CRRUA finally come into compliance with the 2016 ACO?
I believe it was around 2023.
It is my understanding that NMED then took a quarterly compliance sample on April 25th, 2023.
That sounds correct.
When were the reports from the April 25th, 2023 sample received, if you remember?
If I remember correctly, it was several months after the fact. I think it was in September of 2023.
The next quarterly compliance sample was would have been around August 15th, 2023.
That sounds correct.
And do you know when the report from that sample was prepared?
I don't recall the exact date, but it was again several months after the fact. I believe it was in November of that year.
Were the April 2023 sample results over the legal maximum contaminant level for arsenic?
I believe they were.
Did that April 2023 sample result in a violation in and of itself?
I don't believe so.
And why not?
Because if I recall correctly, that single sample did not constitute a violation because the overall running annual average for arsenic hadn't been exceeded at that point.
Was the August 2023 sample above the legal MCL?
If I remember correctly, it was.
How did that impact the running annual average?
I believe that particular sample did raise the running annual average above the MCL, which eventually led to us issuing the notice of violation to CRRUA.
Do you know when the department issued that notice of violation for that exceedance?
I don't recall the exact date, but in general, we issue those violations anywhere from a couple of days to a few weeks after we receive the results.
To your recollection, is that what happened in this case?
Yes.
It wasn't something the department found out and then sat on or waited for?
Absolutely not. We have established protocols where we try to issue violations as timely as possible so that the public can know what the water quality is that they're drinking.
Do you know the reason for that department policy?
Mainly to ensure that we're notifying water systems that they are out of compliance, for one, and also, as I mentioned, there are public notice requirements for violations, and we want to ensure that the public understands when their water system is out of compliance.
Can you tell us what else happened in December 2023 regarding CRRUA?
Yes. So in December, I believe it was December 1st, we received reports that CRRUA that there was high levels of pH in their system, and that was that was confusing to me because I don't recall ever hearing of that happening at any other water system. So I really didn't know what was going on at the time.
I'm going to pause you there for just 1 second. Before you issued the notice of violation for the arsenic exceedances, was that something that had been reported to your department by CRRUA?
Not that I'm aware of, no.
Going back to the pH levels, was that one of the violations identified in the 2024 ACO?
I believe it was.
And did CRRUA receive a notice of violation related to those pH levels?
Yes, they did.
Do you recall what that violation was regarding specifically?
I believe it was for failing to notify their customers and for failing to notify their customers in a timely manner.
Do you recall the other violations that were identified in the 2024 ACO?
If I remember correctly, there were violations for failing to resolve significant deficiencies from the 2019 sanitary survey, also for failing to resolve significant deficiencies from the 2023 sanitary survey. I believe there was some MCL violations related to arsenic. And then the public notice violation, I believe, was also in there.
Did the ACO include a violation for CRRUA's action in relation to their arsenic treatment plants?
Yes, I believe one of the violations was for, if I remember correctly, bypassing their arsenic treatment plants.
Other than
Madam Mayor, can I just ask, has there been a foundation laid for how he has that knowledge of the administrative compliance order? I wasn't sure I heard it.
I don't think I heard it either.
Mr. Martinez, in your role as the Drinking Water Bureau Chief, do you review administrative compliance orders before they're issued?
Yes, I do.
Did you review the 2024 administrative compliance order that was issued on February 2nd, 2024?
Yes, I did.
Did you also review the first amended administrative compliance order that was issued on March 1st, 2024?
Yes, I believe I did.
Are you familiar with the violations described in that, both the original and first amended ACO?
Yes.
And you just described those violations for us, is that correct?
That's correct.
Other than the violations that are listed in the ACO, what else is described in the ACO?
I believe in that particular administrative compliance order, we also listed penalties that were being assessed to CRRUA as well as timelines for compliance.
Before the order was issued on February 2nd, 2024, and then amended in March of 2024, you did review those orders.
I did.
Did you also review the penalty calculations?
I did.
How were the penalties calculated to your knowledge?
To my knowledge, they were calculated in accordance with our enforcement and penalty policy.
Who originally did the penalty calculation?
Our enforcement coordinator, Maria Medina, calculates all penalties for all of our enforcement cases.
And you review those calculations?
I do.
Were you aware at the time that you reviewed those penalty calculations that there may have been some miscalculations in relation to the second violation?
No, I was not. That was unfortunately one of the things that I missed during my review.
Was it intentional to overlook that?
Absolutely not. As we regulate over 1,000 public water systems across the state, there are times where we make mistakes, and when we discover those mistakes, we do everything in our power to correct them as quickly as possible.
There's just one more area regarding the penalty calculations I'd like to clarify. The third violation in the administrative compliance order relating to CRRUA's failure to correct significant deficiencies from the 2019 sanitary survey, that was almost a 4-year time span for those significant deficiencies that existed, correct?
That is correct.
And our understanding from Ms. Medina's testimony this morning is that she actually kept the number of days at 60. Is that correct?
That is correct.
Is that consistent with your penalty policy?
It is consistent with our policy.
So could NMED have included every single day of those 4 years?
Yes, that's part of our discretion.
I'm going to do some math.
Okay. Better you than me.
Based on my calculation, if we had calculated all 4 years every day, that would have been 1,426 days. Does that sound correct to you?
That sounds pretty close, yes.
And the total assessed penalty for $420 at 60 days for violation number 3 totaled $25,200. Does that sound right?
That sounds correct.
If NMED had calculated the $420 per day violation for all 1,426 days, that would have given us a total of nearly $600,000. Does that sound correct?
That sounds, yes, correct. That sounds in the ballpark.
So NMED used its discretion in calculating the penalty for violation number 3 to assess a much lower penalty than it could have.
That is correct.
Why did NMED exercise its discretion in that way in regard to this penalty?
One of the things that we try to do is ultimately the objective of any administrative compliance order is compliance and ensuring that customers are being provided drinking water that meets all regulatory standards. And so when we're issuing a penalty to a water system, we don't want that penalty to be so high that ultimately it is a negative impact to the customers of that water system. But at the same time, we want to make sure that they understand that the seriousness of the violations and that we take compliance very seriously.
The penalty policy, as described by Ms. Medina, also includes a section for a good faith reduction or a bad faith enhancement, correct?
Correct.
Can you describe that section for us?
Sure. It gives the department the discretion to adjust penalties based on good faith efforts from water systems to maybe come forward if there's a violation and work in good faith towards compliance. On the other side is if we feel like a water system is working in bad faith or not being forthcoming about something, it gives us the discretion to enhance the penalties because of those bad faith efforts.
In the initial penalty calculations, did the department calculate a good faith reduction or a bad faith enhancement?
No, we did not.
Do you recall what the total amount of the assessed penalties in the original calculations without the good faith or bad faith adjustments?
I believe it was in the neighborhood of $250,000 to $252,000.
Has that the total amount of penalties the department is seeking, changed since the original order and since the first amended order?
Yes, it has.
Can you tell us how?
Some of the penalties were reduced.
And why were some of the penalties reduced?
Because we found that there was a miscalculation in the penalties that we had assessed.
And that relates to violation number 2, is that correct?
I believe that is correct.
And what was changed about that penalty calculation for violation 2, if you recall?
If I recall correctly, we issued or we calculated the penalty at more days than what we should have, which caused the penalty to be more than it should have.
Did the gravity factor also change for violation number 2?
If I recall, it did.
It was reduced.
It was reduced.
When the penalty was recalculated between the first amended ACO and the second amended ACO, did the department apply that good faith or bad faith adjustment?
No, we did not.
And without applying those adjustments, what was the total penalty calculation?
If I recall correctly, it was in the neighborhood of approximately $168,000.
Mr. Martinez, I'd like to direct your attention to NMED's exhibit number 1 in that notebook, which has already been admitted into evidence.
NMED's exhibit number 1?
Exhibit number 1.
Okay.
Can you just remind us what NMED's exhibit number 1 is?
This is our drinking water enforcement and penalty policy.
Mr. Martinez, can you go to page 5 of that penalty policy for me?
Okay.
And can you just read that paragraph into the record that's under the number 3?
Sure. It's number 3, adjustment for good or bad faith. And it says, evaluate whether the violator acted in good or bad faith. A good faith reduction per violation of up to 50% may be applied if the violator discovered the violation, promptly reported it to NMED, and is making an effort to resolve the violation. In contrast, a bad faith enhancement of up to 50% may be applied if the violator had previously been warned, has a history of noncompliance, knew or should have known that the conduct violated the law, or is not taking action to resolve the violation. This enhancement is calculated against the total penalty violation and rounded to the nearest whole dollar.
Based on what you just read, Mr. Martinez, for the good faith reduction, does a water system have to satisfy all 3 conditions from that definition?
Yes, based on our interpretation, they do.
And what about that sentence makes you believe that?
It says a good faith reduction per the violation may be applied if the violator discovered the violation, promptly reported it to NMED, and is making an effort to resolve the violation.
So you emphasize the word and.
Correct.
Does that mean and suggests all 3 have to be satisfied?
In our interpretation, it does.
Is it mandatory that if all 3 of those conditions have been met, a good faith reduction be applied?
It is not mandatory.
Is the bad faith enhancement mandatory?
It is not.
So similar to the good faith, my question about the good faith reduction, for the bad faith enhancement, does a water system have to satisfy all 4 conditions that you read to us?
No, based on our interpretation of this, it does not.
And can you tell us why?
Because one of the words within this this paragraph, I believe, says or, so that in our interpretation, that means that either one could be true.
So any of the 4 conditions could be satisfied.
Correct.
For. So just to be clear, for a public water system that has a history of noncompliance, that history of noncompliance alone is enough for that public water system to qualify for the bad faith enhancement.
Yes, that we have the discretion to do that.
Would a water utility authority or public water system with CRRUA's history of noncompliance typically be the type of water system the department would consider for a good faith reduction of penalties?
No, not typically.
Did CRRUA promptly notify the department of the bypass or the high pH levels?
No, they did not.
It's my understanding from the administrative compliance order that was issued, those arsenic treatment plants had been bypassed for over a year. Is that also your understanding?
That is my understanding.
And we heard testimony earlier this morning that the pH levels existed for a number of days before CRRUA alerted NMED.
That is correct.
Did CRRUA take steps that the department would consider acts of good faith?
No.
Did CRRUA take any steps towards improving their system?
I'm sorry, could you repeat the question?
Has CRRUA taken any steps to improving their system?
I believe they've taken some steps to improve their system.
Does that outweigh CRRUA's history of noncompliance, for example?
I'm going to object to it. Is there a standard? There's a lack of foundation. I mean, is there a standard? I don't think that he's actually testified in regards to how he would be able to evaluate that, or in what context he would evaluate that. She's asking kind of like in the sort of this vacuum of sort of any cognizable, recognizable standard that may actually support that other than his pure opinion.
Madam Hearing Officer, if I may respond. Mr. Martinez has testified that he oversaw enforcement before it was split off on July 1st and has experience and knowledge of the penalty policy and the violations at issue. He has also spoken at length about the discretion that the department has when applying the penalty policy. I think he is qualified, more than qualified, based on his 15 years of experience with the department to offer testimony about his evaluation of these violations and whether or not the various factors and how they weigh against each other.
Okay, and I myself was a little confused by the original question because I think you asked the word would one outweigh the other. And if we are talking about the penalties in this case and the ACOs and amended ACOs in this case, I would think the word would be did.
I'll re-ask the question with that clarification. Mr. Martinez, did the operational steps that CRRUA has taken to did the operational steps taken by CRRUA outweigh its history of noncompliance?
No, they did not.
And just before, at the time of filing the second amended administrative compliance order, did the department make the decision to apply either the good faith reduction or the bad faith enhancement?
I'm sorry, could you repeat the question?
Has the department, as we sit here today, applied either a good faith reduction or a bad faith enhancement?
Yes, we have.
And which one?
We applied a bad faith enhancement to the penalties.
To all 5 violations?
Correct.
In addition to the good faith and bad faith adjustments, is settlement a way that the penalty calculation or the penalty amount could change?
Yes.
And in the administrative compliance order, is the public water system instructed to reach out to certain individuals to discuss settlement?
Yes, in every compliance order that we issue, there are instructions to reach out to various people. Generally, it's to our enforcement coordinator or the bureau chief or our Office of General Counsel.
And there are certain things that have to be considered, and certain things that may be considered in those settlement discussions.
Correct.
And is one of those things that can be considered a system's ability to pay?
Yes.
Is that something that the department is required to consider?
It is an option within our enforcement and penalty policy.
Did CRRUA reach out to anyone to discuss settlement of this administrative compliance order?
Yes.
To your knowledge, did CRRUA request a reduction for their ability to pay?
I believe that they did.
Did you consider that reduction requested?
No, we did not.
And why not?
Because CRRUA never provided any documentation of their inability to pay. Our penalty and enforcement policy lays out that there should be some kind of documentation to substantiate that they don't have an ability to pay.
I'm going to direct your attention in exhibit number 1 to the second to last paragraph on page 5.
Okay.
And near the end of that paragraph, it states, the Bureau should only consider the inability to pay if the violator provides evidence of such inability, typically 3 years of tax returns. Did I read that correctly?
That is correct.
To your knowledge, did CRRUA ever provide 3 years of tax returns?
Not to my knowledge.
Can the department also consider offering a violator the option to pay the penalty over time?
Yes, we can.
Is that something that the department has offered CRRUA in this case?
Yes.
And
I think I'm going to object now. I think that we are getting into, we've already been there, but these are confidential settlement negotiations. This is the substance that she's discussing, is 1140.
Okay.
Madam Hearing Officer, I don't believe we're treading on that territory. And I also believe that this is highly probative evidence given CRRUA's request for the ability to pay reduction that I believe we will hear significant testimony about during their case.
Are you going to address that during your case?
We are going to address ability to pay requests through our direct testimony. But I think to say that highly probative evidence from confidential settlement negotiations has a bearing on that. That doesn't compute at all.
Right. So again, I don't listen to evidence about an actual settlement discussion. Can you talk about the ability to pay issue without laying that out?
My question was simply, was the ability to pay reduction considered in offering CRRUA the opportunity to pay over time?
Oh, which is
believe-
addressed in the penalty policy.
It is.
I believe the question was in the context of this settlement, these settlement
That
negotiations.
was not the question.
I'm
The
not saying,
question,
I'm saying that during the course of this conversation, she's cited to the specific settlement policy in the penalty policy, stating that there's an ability to pay if the violator provides evidence of such an ability. And she's saying, CRRUA, NMED, did NMED offer CRRUA to pay over time? That offer is necessarily part of confidential settlement negotiations. I mean, that is the context for which it was made.
All right. So I think we can fix this. The policy states that consideration should first be given to allowing the violator to pay the penalty over time. So I think a perfectly legitimate question is, did the Bureau consider that as a way of resolving the matter without saying, did you offer and did they refuse? Just a suggestion.
thank you, Madam Hearing Officer. Mr. Martinez, did the Bureau consider giving CRRUA the opportunity to pay over time?
Yes, we did.
Mr. Martinez, I want to shift a little bit to the Drinking Water Bureau's obligations when it receives new information during the course of an enforcement action. So directing your attention back to page 5, the last paragraph. Can you read the first sentence for us?
Yes, the DWB must recalculate the civil penalty whenever it obtains new information affecting the basis for the civil penalty.
And just for clarification on the record, the DWB is the Drinking Water Bureau.
Correct.
And what does that sentence mean in your interpretation?
In our interpretation, it means that if we receive new information regarding compliance or other things with respect to the civil penalties, we have to take that into consideration.
It's not discretionary.
No.
It's mandatory.
Yes, in our interpretation.
In this case, did the department receive new information that indicated the penalty had to be recalculated?
Yes.
Can you tell us what that new information was?
In, I believe it was April and May of 2024. I remember the exact timeline, but we received information that CRRUA's voluntary samples had exceeded the standard for arsenic, and so we took that into consideration.
And would those voluntary samples have been in, is it possible they were in 25?
Yes, it could have been in 2025.
And you said those voluntary sample results were from April and May.
I believe so, yes.
Did NMED take a quarterly sample around this time frame as well?
I believe we did. I believe we took a quarterly sample in May as well.
And do you recall the results of that sample, that quarterly sample?
Yes, that quarterly sample was also above the arsenic standard.
And just to make sure we're all on the same page, what is the arsenic standard?
The standard is 10 parts per billion.
And so those, you mentioned 2 voluntary tests and the quarterly test, those were all above.
Correct.
And how did you learn about those voluntary test results?
If I remember correctly, I learned about it through a couple of different ways. One of our Southern compliance staff alerted me to that. And then I believe a local media outlet had contacted the department to ask about a press release that had been issued by CRRUA.
Did CRRUA reach out to you directly?
They did not.
You were one of the individuals identified in the ACO for CRRUA to reach out to.
That is correct.
Why, when the original administrative compliance order was issued, did NMED not include a good faith reduction or bad faith enhancement?
Because we didn't feel like either was applicable at the time.
And did the information about the exceedances in April and May of 2025 change that analysis?
Yes, it did.
And how did it change your analysis?
At the time, I believe that the department and CRRUA were in active settlement negotiations, and there was no mention of these exceedances during any of that. And
I'm going to object again. I mean, just testifying about confidential settlement negotiations.
Okay, so don't do that.
Okay.
You can finish your answer.
Okay.
Ma'am, objecting to the answer. I think she said, "Don't do that."
Right. So
he's
I
not
think
going to do that again.
I think he understands not to talk about what was discussed in the settlement negotiations, but he can still finish his answer otherwise.
CRRUA did not notify anyone listed in the administrative compliance order about these exceedances.
Mr. Martinez, I'd like to direct your attention to what has been marked as NMED's exhibit number 25. Is there any objection from counsel for CRRUA to exhibit number 25?
Oh, give me a second. What is it again?
A May 9th press release by CRRUA.
Press release by CRRUA?
Yes.
No objection.
Madam Hearing Officer, I'm very sorry. It's very warm in here. Do you mind if I take my jacket off? Thank you. Mr. Martinez, can you tell us what NMED's exhibit number 25 is?
Yes, it looks to be an April 2025 press release from the CRRUA water system.
And what was the date that press release was released?
May 9th, 2025.
And it's concerning the April 2025 arsenic exceedances?
Correct.
I want to direct your attention to the third paragraph in exhibit number 25.
Mm-hmm.
There's a quote that says, quote, "When we received the test results for the Santa Teresa Industrial ATF arsenic treatment facility, we immediately implemented protocols and standard operating procedures, SOPs. We initiated in partnership with NMED an adjusted treatment that lowered the arsenic to below the MCL," said CRRUA Executive Director Juan Crosby. Did I read that correctly?
Yes, that was correct.
To your knowledge, did CRRUA, quote, immediately, end quote, take the steps necessary that, quote, lowered the arsenic to below the MCL as represented here?
No.
And how do you know that?
Because there was subsequent samples after this press release came out that were also above the arsenic standard.
Mr. Martinez, I'm going to next ask you to turn to what is marked as NMED's exhibit number 24. Counsel, is there any objection to the admission of NMED's exhibit number 24?
No objection.
Thank you, Madam Hearing Officer. Mr. Martinez, can you tell us what exhibit number 24 is?
Yes, this looks to be an analytical report from a laboratory that was used by CRRUA.
And what is the date on page 1 of when this report was generated?
This was generated on April 30th, 2025.
And is this to your knowledge, analyzing the April 24th voluntary test results?
I believe it is.
So if this report was generated on April 30th, 2025, what does that tell us about when CRRUA knew or should have known about the arsenic levels in those samples?
It shows that they either knew about the samples or should have known about the sample results on April 30th or very shortly thereafter.
And on page 1, it says prepared for attention Eric Lopez, correct?
Correct.
Eric Lopez is the contract operator for CRRUA, is that correct?
I believe that is correct.
If CRRUA knew about the results from the April 24th, 2025 samples on April 30th, but did not issue the press release describing those results until May 9th, how long did CRRUA wait to notify the public of its exceedance?
I believe that's approximately 9 days.
Do you know how CRRUA's customers responded to the May 9th, 2024 press release?
I object to the extent that it relies on hearsay. Also, lack of foundation.
Overruled.
Do you want me to ask the question again, Mr. Martinez?
Sure.
Do you know how CRRUA's customers responded to the May 9th, 2024 press release?
I believe that many of their customers were rightly upset about the information that they were being provided.
Mr. Martinez, I'd like to direct your attention to what has been marked as NMED's exhibit number 26. Any objection to the admission of NMED's exhibit 26?
Yes, I do object. That document is hearsay. It's not generated by NMED. It's not a document that is a government record. That document there's no foundation, lack of authentication, and that document's just got problems across the board.
Madam Hearing Officer, exhibit number 26 is a public record. It's been available since May 9th, 2025. And I simply want to ask about Mr. Martinez's understanding of this letter, not what it means or his.
Madam Secretary, Hearing Officer, to my knowledge, Empowerment Congress is not a governmental entity. I mean, this is what I understand is that it's at best a nonprofit, which is not a governmental entity. It's not a business record, not generated by this department. This witness has not authenticated it. This witness, I'm not sure it can authenticate it under the rules of evidence. And in addition, it's just blatant hearsay.
All right. So I would like Ms. Nixon to lay some groundwork here with Mr. Martinez and focus, obviously not, it doesn't seem like it's something he prepared, but whether he was aware of it and took some action in response to it, regardless of who prepared it.
But I think, Madam Hearsay, I mean, there's an authentication objection. I mean, you have to be able to authenticate a record. I mean, I don't know if a witness can say I was aware of a record and that's thereby authenticated. That's not what the rules of evidence require.
And Madam Hearing Officer, the rules of evidence don't strictly apply in this hearing.
No, they don't. But I mean, we're making legal arguments, and I said before, this is as close to a quasi-judicial hearing as you can possibly get. And
it's in the hearing officer's discretion.
Absolutely, it is.
All right. So the objections are overruled. And if you would please explain have Mr. Martinez explain what meaning this document had to his work, please.
Thank you, Madam Hearing Officer. Mr. Martinez, have you seen what has been marked as exhibit number 26 before today?
Yes, I have.
Are you familiar with the document that is marked as NMED's exhibit number 26?
Yes.
Are you also familiar with the contents of that exhibit?
Yes.
And what is NMED's exhibit number 26?
It is a letter from an organization called Empowerment Congress, and it's a response to CRRUA's press release.
To your knowledge, is NMED's exhibit number 26 a true and correct copy of the letter from Empowerment Congress?
A continued objection that hasn't really been properly authenticated.
Yeah, and I understand your objection, and again, would not be relying on it for, if you will, the truth of the statements in it as a document that way. I'm more interested in what actions Mr. Martinez took as a result of receiving it.
Thank you.
That's what I want to hear.
And then, Madam Hearing Officer, do I understand your ruling to be that lines of question can be directed to Mr. Martinez in regards to any actions he took in response to this, but not that go to the truth of the matter asserted in the substance of the.
Right, unless he has some independent knowledge of it.
Thank you.
Yeah. Okay, please go ahead.
Thank you, Madam Hearing Officer. Mr. Martinez, what is your understanding of what is described in the letter from Empowerment Congress?
Object then. I mean, now he's testifying about the substance of the letter and not anything he did in response to it.
Okay, so he can, in order to talk about what he did in response to it, we need to hear from him what his understanding of it was when he read it. So,
Objection for the record.
yeah, all right. Please go ahead, Mr. Martinez.
My understanding of what this letter is that it shows that Empowerment Congress had been in contact with many CRRUA customers and had essentially details their frustrations with the water system.
And I'm sorry, Madam Hearing Officer, before we move on, I would like to move to introduce NMED's exhibit number 26 as evidence in this matter.
All right, so again, exhibit 26 is admitted, and just to be, I hope, very clear about my stance on it, I'm not going to accept without question each of the individual statements, representations made in it, without some, supporting evidence from someone who drafted it or investigated it. I am interested, though, in what Mr. Martinez's understanding of it was and what actions he took in response.
Thank you, Madam Hearing Officer. Mr. Martinez, I want to direct your attention to the last paragraph on page 2 of NMED's exhibit number 26. Would you just take a second and read that to yourself?
Okay.
And what is your understanding of that last paragraph on page 2?
That there was a total of 93 distinct complaints, 17 occurring between January 14th and April 14th, 2025.
What did NMED learn from this letter from Empowerment Congress?
Just about the number of customers that were upset at the notice of the elevated arsenic levels and just the number of complaints that had been issued to CRRUA.
And were those complaints directed to CRRUA or did NMED receive those?
I believe that we received some of these complaints as well.
I'm sorry, I couldn't catch that.
He believes the department received some of these complaints as well.
And Mr. Martinez, in evaluating the civil penalty and the bad faith enhancement that was applied after this time, did these customer complaints impact the department, the Bureau's analysis?
I don't think they impacted them directly, no.
Next, I want to direct your attention to what has been marked as NMED's exhibit number 27. Any objection to the admission of exhibit number 27, Council?
No objection.
Mr. Martinez, would you just tell us for the record what NMED's exhibit number 27 is?
Yes, this is another laboratory analytical report that for some samples that were submitted to this particular lab by CRRUA.
And do you know the date of those samples?
The date of the samples, I believe, were in May of 2025. And to be specific, the report says that the date that the samples were collected were May 6th, 2025.
Thank you, Mr. Martinez. And on page 1, when was this report generated?
May 12th, 2025.
And again, this report states it was prepared for CRRUA's contract operator, Eric Lopez, correct?
Correct.
So if the report was generated on May 12th, when did CRRUA knew, or when should they have known about the arsenic levels collected on May 6th?
Either on May 12th or very shortly thereafter.
Next, I would like to ask you to turn to NMED's exhibit number 28. Any objection to the admission of exhibit number 28?
No objection.
Thank you, Madam Hearing Officer. Mr. Martinez, could you just tell us for the record what exhibit 28 is?
Sure. This is a press release from CRRUA to their customers, letting them know about the first follow-up arsenic test completed.
And what is the date of that press release?
May 15th, 2025.
And so if the date of the press release is May 15th and they knew of the sample results on May 12th, how long did they wait before notifying the public of those sample results?
Approximately 3 days.
Mr. Martinez, you mentioned that NMED performed a quarterly sample in this same time period. Is that correct?
That is correct.
Do you know the date of that quarterly sample?
I don't recall the exact date that the sample was collected.
If I told you it was May 7th, 2025, would you have any reason to disagree with that?
No, I wouldn't.
Mr. Martinez, I'd like to direct your attention to what has been marked as NMED's exhibit number 29.
No objection.
Thank you, Madam Hearing Officer. Mr. Martinez, can you tell us what exhibit 29 is?
Yes, this looks like it is a screenshot from our drinking water watch database, which shows all of the various samples that are collected across the state.
And according to this exhibit, this was the test results from the industrial park treatment plant?
I believe so, although this particular thing doesn't say specifically that it's from there.
What was the arsenic concentration noted in the results in front of us?
15 parts per billion.
Do you know what the test results were from the voluntary tests on April 24th and May 6th, 2025?
If I remember correctly, they were 12 parts per billion.
So between the time of the voluntary test and this quarterly test, the arsenic level had actually increased?
According to the test results, that's correct.
You testified that there were test results in April and May, which indicated CRRUA was not acting in good faith. Have we discussed all those test results?
I don't recall. I think we have.
Did those results constitute new information?
Yes, they did.
new information that was necessary for recalculation of penalties.
Yes.
How did those new test results, what was recalculated based on those test results?
We used, as part of those results, and essentially as part of those test results, we recalculated based on the bad faith enhancement that is at our discretion.
And was it just the fact that there were exceedances, or did CRRUA's notice about those exceedances affect your analysis?
It was also the failure to notify us in a timely manner, and also failing to notify the public in a timely manner.
Can you explain in your own words, based on your own experience, why it matters that they didn't notify their customers as it relates to the application of the penalty assessment?
Sure. So the whole, one of the bases of the Safe Drinking Water Act and the regulations that are part of the Safe Drinking Water Act is that you're providing your customers with information about their water quality, and you're providing it in a timely manner, and that gives the customers the ability to make informed decisions for themselves about whether or not they want to consume that water. So informing customers essentially is a water system's responsibility, so that customers are informed and protected.
And why is it important for customers to be informed about arsenic levels specifically?
Because it is elevated levels of arsenic could potentially have health effects to individuals.
And does CRRUA's delay in providing public notice about these exceedances suggest they were less than transparent?
I'm going to object. Speculation.
You're asking him in his opinion as a regulator? Yeah. Yeah.
Exactly.
No, I think that's an okay question. Overruled.
Can you repeat the question? I'm sorry.
Yes, of course, Mr. Martinez. In your experience as a regulator, does CRRUA's reluctance or delay in notifying the public suggest a lack of transparency by CRRUA?
Yes, I believe it does.
But your department, your bureau, did not assess any new actual violations or additional penalties, new penalty calculations based on this information.
No, we did not.
And can you tell us why not?
Because those specific samples did not raise to the level of a violation of the Safe Drinking Water Act.
The voluntary tests, did they impact the running annual average?
They did not.
And since they did not count in the running annual average, they could not have caused the running annual average to exceed the MCL.
That is correct.
But what are those sample results evidence of, in your opinion, as a regulator?
They're evidence that their operations and how they were operating those specific treatment plants obviously wasn't working because the arsenic levels had been elevated.
Is it evidence of good faith by CRRUA?
No.
Is it evidence of bad faith by CRRUA?
It could be interpreted as bad faith, yes.
Based on the definition from the penalty policy we read.
Correct.
So based on this information, just remind us again, how did NMED change its penalty assessment in this case?
We
I'm going to object. I think he's testified very clearly, asked and answered. He's testified very clearly how they changed their penalty assessment, gone over every single factor.
I'm
think
just
she's
laying the
asking-
foundation for my next line of questions.
Is there new information?
There's
Because
another line of questions, and I'm just laying the foundation to start that line of
okay,
questions.
because the way it said is that you sort of repeated the question before. How did you recalculate the penalty?
It's a transitional question.
Perfect.
Thank you, Madam Hearing Officer. Would you like me to repeat that
Please.
question? Would you remind us again, just for the record, how NMED changed its penalty in regard to CRRUA based on this new information?
Yes.
I'm going to object. I mean, that's the saying, remind us.
It's still a transitional question,
Yeah.
Mr. Trujillo.
But it's literally cumulative. It's literally asked and answered. You remind
She's
us again.
overruled this objection once.
I can object every time you ask me a question.
He asked
Okay.
me to repeat the question.
All right. I'm sorry. It now has been a while. Please answer it as briefly as you can, Mr. Martinez.
We took this new information and implemented a bad faith enhancement to the original penalty.
Mr. Martinez, are you the person who recalculated those penalties with the bad faith enhancement?
Yes, I was involved in that.
And did you do that on your own?
There was a collective discussion amongst a lot of individuals within our agency, but ultimately I was the one that recalculated them.
What level of bad faith enhancement did you apply to each of the penalty calculations?
50%.
For each penalty?
Correct.
With that 50% enhancement for all 5 penalties, do you recall what the total penalty was?
I believe it was approximately $252,000.
So after the penalty had been recalculated to correct the errors on violation 2, with the enhancement for bad faith, it was about the same as the original penalty.
Correct.
And we discussed earlier that the total violation for violation number 3 related to the 2019 sanitary survey could have been much higher than that total penalty.
That is correct.
So the total penalty, even with the bad faith enhancement, is still less than the total penalty that could have been assessed for just one violation.
Yes.
Mr. Martinez, you've heard a lot of testimony and you've talked with us a lot today about CRRUA's violations, failures to correct significant deficiencies, intentional bypassing of their arsenic treatment plants, arsenic exceedances. What does all this tell you, in your opinion as a regulator, about CRRUA?
That they have a pretty lengthy history of noncompliance, and they also have a history of coming briefly back into compliance, but then falling out of compliance again. So it's just a pretty lengthy history of failing to comply with the regulations.
And CRRUA has issued NOVs in the past.
I'm sorry, what was the question?
CRRUA has issued NOVs in the past, correct?
Correct.
And CRRUA has issued ACOs in the past.
We have issued ACOs to CRRUA in the past. That is correct.
And despite those enforcement actions, has CRRUA worked with your bureau in good faith to attain sustained compliance?
Not. They have not had sustained. They have not worked with us in a sustained manner over the years.
Are you concerned about CRRUA as a regulator? Are you concerned about CRRUA's long-term compliance?
Absolutely.
Can you tell us why?
Sure. Because when you have as long of a history of noncompliance as CRRUA has, it's concerning because they have a pretty large customer base, and that customer base deserves to be provided compliant and sustainable drinking water.
What is the risk of, if you know, in your experience as a regulator, do you understand some of the risks of arsenic being in water distributed to customers?
I
I will object to the extent that it's going to approach any technical testimony in regards to public health.
Would you leave the foundation first, please?
Mr. Martinez, you've been a regulator of public water systems for a long time, correct?
correct,
For your entire career.
correct,
And you've been with the New Mexico Environment Department for 15 years,
correct,
regulating drinking water systems.
correct.
And are you familiar with the New Mexico drinking water regulations?
Yes,
Are you familiar with the federal regulations incorporated into those regulations?
yes,
Are you aware that the EPA has issued guidance regarding arsenic standards in the federal regulations?
yes,
And isn't it true that the EPA describes the rationale for arsenic regulations in that guidance?
yes.
Based on your understanding of the regulations and the guidance from the EPA, what are some of the health effects of arsenic in drinking water?
I'm going to object again. I mean, the regulations speak for themselves.
No, I think you can answer this overruled. Go ahead, Mr. Martinez.
Sure. I don't know the specific health effects, but I do know that EPA has put out a lot of guidance, and there are some pretty significant health effects for long-term ingestion of drinking water that has elevated levels of arsenic.
Given your experience with CRRUA as the bureau chief and your experience prior to being the bureau chief with NMED, do you believe that CRRUA has demonstrated good faith compliance efforts?
Not at this point, but I'm hopeful that that happens at some point in the future.
What does the new information from the voluntary tests and the compliance sample indicate to you about CRRUA?
It indicates that they still have some things to work out. They still have, a lot of improvements to do, and ultimately, it still shows that they worked in bad faith, in our opinion.
In your nearly decade and a half, over a decade and a half of experience with the department, do you think it would be appropriate to apply a good faith reduction for the penalties assessed in this matter?
Not at this point, no.
I have no further questions for you at this time, but I would like to reserve the opportunity for redirect examination.
All right, thank you. I have one question. It might be helpful if I ask it before you begin your cross-examination in case you want to follow up on it. You're aware that the Environmental Improvement Act limits penalties assessed for violations of drinking water Bureau regulations to $1,000 per violation per day maximum.
Yes.
Okay. Would the bad faith enhancement of a penalty ever result in a penalty, or did it result in a penalty in this matter? I won't ask you to speculate. That blows past that $1,000 per day per violation.
No, not to my knowledge.
Thank you.
Madam Hearing Officer, yeah. I was hoping we could take a short break before cross-examination.
Certainly. Yeah, we've been doing an hour, 15 minutes, I guess, at this point. Alrighty, let's take 15 minutes.
2:15.
Thank you.
Uh, Mr. Trujillo?
Hello, Mr. Martinez. How you doing?
Very good, thank you.
Towards the end of your testimony, you testified that you're familiar with the CFRs. Is that correct?
Correct.
You're familiar with the drinking water regulations.
I am.
And I think you heard Deputy Cabinet Secretary's testimony that you authorized the Love's Truck Stop shower sample. Is that right?
I was part of that discussion, and yes, I was involved in that.
So when you authorized or when you took part in the authorization of the Love's Truck Stop shower sample, you knew that that sample didn't comply with the CFRs, right?
It was not intended to comply with the CFRs, but yes.
So it was not intended to comply with the CFRs.
Correct.
So what was the legal authority for you to take that sample?
I don't think we are required to have legal authority to investigate or take samples when we feel like it's necessary to take samples.
So you feel like in your investigation, you can go and take samples from a source that is not authorized by the CFR, right?
Correct. Yes, that is correct.
And then you can issue a press release that does not state that that sample was not taken from a valid source.
Yeah, I did not issue the press release.
Did you contribute to the press release?
Not that I recall, no.
Okay. Now, who drafted the press release? If you know.
I don't recall it. It was more than likely a combination of our communications director and maybe some other individuals.
So did you communicate the results of that, the Love's Truck Stop shower sample to someone so that they could put it into the press release?
I don't recall specifically, but I would assume that I had copies of those results at a certain point.
I'm sorry?
I said I do not recall specifically if I provided them, but I do recall seeing copies of those results at a certain point.
Okay. You didn't transmit them forward, though?
I don't recall doing that specifically, but I could have been one of the people that did that.
Thank you. You testified that the 2016 Administrative Compliance Order was not completed until 2023. You do know that NMED agreed to extensions of compliance formally, correct?
Yes.
And you also testified that Maria Medina calculates all penalties for the Drinking Water Bureau.
That's correct.
Except for, so if Maria Medina calculates all penalties for the Drinking Water Bureau, the administrative penalty that you calculated or recalculated is the only penalty that she hasn't done?
To my recollection, that is correct.
And you calculated that penalty. So then the penalty in this case, in the second amended administrative compliance order that you calculated is the only penalty that Maria Medina did not calculate.
Correct.
He also testified about the 60-day cap in the penalty policy. And I believe your testimony was something to the effect of that the Drinking Water Bureau likes to implement that. I'm not sure if likes the right word, but they, apply that 60-day cap because you don't want to have a negative impact to the customers of the entity, right?
That was part of my answer, correct?
Is there another part that I'm missing?
Yes, the other part of that was that we want to make sure that the water system understands that the seriousness of the violations and that we take compliance seriously.
Right. So it's a balancing act.
Correct.
So you balance those two. And so if there were testimony that the civil penalty in this case would have a negative impact to the customers of CRRUA because CRRUA is going to have to pass that on to the customers, would that have changed your calculation or would that have changed your consideration of an ability to pay reduction if you knew that that was going to impact the customers?
I don't know. It may have.
Did you know that there was, did you know that that could have the possibility of impacting the CRRUA customers when you recalculated the penalty?
That wasn't something that I was specifically thinking about at that point in time. So no.
And you also testified that operational steps that CRRUA has taken outweigh its history of compliance in looking at a good faith reduction, right?
Correct.
What are the operational steps that CRRUA has taken?
Objective foundation. He may or may not know those, and I
Well,
don't think he's established whether he
you
does.
asked him if the operational steps that CRRUA has taken outweigh, and he said no. So I mean, I think that implies that he has knowledge of the operational steps. But what are the operational steps that don't outweigh CRRUA's history of noncompliance?
Well, I'm not familiar with every single operational step that they've taken. The things that I am aware of is that they have started collecting voluntary samples at some of their treatment facilities. I believe that they have started, taking operational steps to better manage their treatment facilities as well.
So 2 operational steps: voluntary test samples and operational steps to improve. That's it?
That
He
I'm
just
aware of.
testified that that's what he's aware of.
I'm
I
asking
think you're
you,
badgering
are
the
there
witness.
any others?
There may be. There may be, but I'm not directly aware of them.
So your testimony that those operational steps that CRRUA has taken do not outweigh its history of compliance are limited to those 2 things. If there were more, would that change the calculation or the recalculation in your mind that there are a lot more operational steps here than I knew about?
Not necessarily.
Why not?
Because I wouldn't know what specific steps you would be referring to.
Let's say that I were to say that CRRUA has taken 10 operational steps, and I were to give you, and this is a hypothetical, give you specific examples of these operational steps that they've taken, in addition to the 2 that are 10 total. Would that have changed that testimony, that operational steps?
Objection, Madam Hearing Officer. This calls for speculation.
It does.
It does call for speculation, but I think that he's qualified to know, or he's at least as the Drinking Water Bureau chief, when he says that if there were 2 steps that they took, and that does not outweigh the history of noncompliance, are there more? I mean, I think he's able to say that, yeah, I think that would have changed my mind or not.
But
Madam
asking him to form an opinion on unknown steps in a hypothetical that doesn't give him something to base an opinion on, I think is too speculative.
No problem. You mentioned that the penalty policy calls for evidence of an ability to pay reduction in the form of tax returns. And I think the penalty policy says that, typically the evidence of ability to pay should be demonstrated by 3 years worth of tax returns. Have you ever received tax returns from a governmental entity in any of these negotiations that you've ever been involved in?
Not that I'm aware of.
How many have you been involved in?
How many what have I?
Like negotiations, how many ability to pay reduction conversations have you been in?
I can't recall a single one that I've been in.
You've never been in one?
No.
You've never seen a tax return?
No.
No entity has ever approached you for an ability to pay reduction?
Not that I'm aware of.
So there's an administrative compliance order going on with the city of Las Vegas. They have not requested an ability to pay reduction?
No.
What about Village of Chama?
Not that I'm aware of.
What about Tula Rosa? Tula Rosa, sorry.
Not that I'm aware of.
So in an ability to pay reduction, the tax returns are not the only thing that the department can consider, right? It's just typically.
Well, because we have not typically considered an inability to pay because we have not received any. I'm not sure I can answer that.
That's fair. In regards to the April 24th, 2025 and the May 6th, 2025 voluntary, you've testified, you know about them, you know extensively about them, right?
I wouldn't say extensively, but I do know about them.
You know what they are.
Correct.
Do you know how they play a part in this case?
Yes.
And you testified that your staff informed you of the test. That means that CRRUA informed the staff, right?
Yes.
You also testified that CRRUA didn't inform you personally.
Correct.
And what was the obligation of CRRUA to inform you personally instead of going through Tim Willie, Brandy Littleton, but Martin Torres? Why would that not be good enough for them to report directly to this compliance staff that has authority over them and go directly to you?
I think, in my opinion, they should have done both because there was an active administrative order going on at the time, and that administrative order did specify that they should be reaching out to specific individuals. But in addition to that, as a water system that gets new information that might be relevant to their compliance officer, they should be reaching out to their compliance officer also.
So they did reach out to the compliance officer. And I'm not sure if you said they should have reached out to you or they required to reach out to you.
They should have.
Okay, so they weren't required to reach out to you.
I don't know if it says anywhere that they're required to reach out to me directly about those specific sampling results.
I think you said something about the administrative compliance order mentioning you as someone that they needed to talk to. You have it in front of you. That's the second amended administrative compliance order in this case.
Okay.
Can you find your name in it?
Not that I'm seeing specifically, no.
But you testified that this document listed you as someone to reach out to, but your name is not in it. So how would CRRUA have known by reading this document that they should have reached out to you?
It didn't. There was multiple other people that were also listed on here.
You said you.
Correct.
So the question is, how would CRRUA have known to reach out to you if you're not listed in this document to reach out to?
Well, CRRUA has reached out to me on for other issues, but they wouldn't have known.
You testified about those samples, the May 6th and the April 23rd, 2025. You testified that they were elevated violation levels. But we know those aren't violations, right? Excuse me, I'm sorry. That they were elevated. I was reading my notes. There were elevated levels.
Correct.
They were not violations. That's been gone over many times, right?
Correct.
But yet those samples, in your opinion, that are not violations are evidence of bad faith, correct?
Not the sample specifically, but the lack of action after the results.
The lack of action after results. Let's talk about that then. We already covered the obligation to you, that there is none.
Mhm.
So who should CRRUA, according to that administrative compliance order, who should they have reported those results to?
There was nobody specifically mentioned or voluntary sampling results.
Right. There was nothing specifically mentioned for voluntary sampling results, but there were people mentioned, like contact those people. Who are those people?
According to this document, it was Maria Medina and our general counsel.
Okay. What paragraph is that? Do you know?
So with paragraph 45 lists Maria Medina and our general counsel.
And so what does 45 list? Why would CRRUA contact Maria Medina according to paragraph 45?
Because she is our enforcement coordinator.
But for what purpose does it state in paragraph 45?
It says to explore the possibility of settlement in this matter, contact Maria Medina. If you want to explore settlement and have retained counsel to represent you in this matter, please contact Tatiana Engelman.
Okay. And so the stated purpose is to explore the possibility of settlement.
Correct.
That's the stated purpose. And is CRRUA represented by counsel?
Yes.
So why would CRRUA contact Maria Medina if it's been represented by counsel?
Objection calls for speculation and is lacks foundation. I don't think Mr. Martinez can testify about why CRRUA did or did not do something.
Okay. If you rephrase the question, I'm sure you can work it out.
I'm not sure I understand the objection. Why would CRRUA?
Your question, Mr. Trujillo, was why would CRRUA not contact you directly if they have counsel? And I don't think that Mr. Martinez has the foundation to answer that question. And I also think it asks him to speculate about.
We'll go backwards then. What was your role in the first administrative compliance order as of March 1st, 2024?
Which specific compliance order are you talking about?
That's the first amended administrative compliance order of March 1st, 2024.
I believe I was a reviewer.
You were a reviewer.
I believe so.
And at what point did you become privy to the fact that CRRUA was represented by counsel, if you recall?
I don't recall.
It wasn't until yesterday that you knew that CRRUA was represented by counsel?
No, I wouldn't say that.
Before yesterday, then?
Correct.
Okay. So if CRRUA is represented by counsel, cannot contact Maria Medina, according to this paragraph.
Object to form and foundation. He doesn't know the legal rules regarding.
I'm not asking a question. I'm telling him that if CRRUA is represented by counsel, it cannot contact Maria Medina, according to this paragraph. This paragraph states if you want.
I also think that misstates the rules of professional conduct.
So I think Mr. Trujillo is, I think, trying to make ultimately a very simple point, which is if CRRUA is represented by counsel, the CEO directs them to contact Tatiana Engelman instead of Maria Medina. Isn't that on the face of the CEO?
I think he could ask that question without asking Mr. Martinez to delve into the rules of professional conduct about when clients may or may not contact each other with representation.
But I think he's asking questions from the face of the compliance order. So maybe I misheard you, but that's all you're trying to do here.
Yeah, it was all I was trying to do, but
Okay.
I hadn't finished the question. What I was stating to him is that if CRRUA is represented by counsel, it cannot contact Maria Medina according to this paragraph.
The paragraph does not say that.
I think it
Yes, it does.
effectively says that, but Mr. Martinez, is that your understanding, in fact, that if CRRUA is represented by counsel, they contact NMED counsel instead of, for example, the executive director contacting Maria Medina?
Yes.
Okay.
So, in other words, the obligation, because you said that part of the analysis for bad faith conduct was that responding to these tests, not the tests themselves, the test results themselves are not evidence of bad faith. It's the after. And so part of the after is two things. One is contact with NMED or lack thereof, and two is contact with the public. We're talking about contact with NMED first.
Mm-hmm.
And so if this paragraph states that it cannot, that CRRUA cannot contact Maria Medina if it's represented by counsel, it would contact Tatiana Engelman. Is that your understanding?
Yes.
So this paragraph is the only obligation that you know of that should have put CRRUA on notice that it needed to or should have contacted NMED through Tatiana Engelman about the April 23rd and May 6th tests.
Mr. Trujillo, I am sorry to interrupt. He had just a moment to page through. I do see another reference in another part of the CO that I think we might want to draw his attention to before he answers your question.
Okay, what is?
It's page 5, paragraph 20. Ms. Medina is referenced there as well. And I understand from the face of it that it goes to the compliance submittals. I'm not suggesting that it's any broader than that, but it is a second place in the CO which sets out a department contact. So you might want to cover that as well.
Madam Hearing Officer, does the file in this case contain the first amended administrative compliance order?
I'm very sorry. I thought we were looking at the second amended.
No, that's the question that I'm asking, is if there is the first amended.
Hold on then. I think it does, but this is my book of pleadings and these are my books of exhibits.
Madam Hearing Officer, if it would help you and opposing counsel, we have a copy of the First Amendment.
I have it, but I'd like to, just for Madam Hearing Officer's information, if you wouldn't mind if I could read into the record. I'd like to point out that, and I'm not sure, is this the first amended administrative compliance order part of the record in this case?
That was your question. I immediately started looking through the pleadings in this matter. I'm not noticing it right away. And here's the index of pleadings. Here are all the pleadings. And I don't remember seeing it, and I'm not seeing it in this index.
At this time, Madam Hearing Officer, we would submit that the first amended administrative compliance order, which has been testified extensively about in this case, should be made a part of the record.
Okay, and
No objection.
all right, thank you. Then it will be. I'm just not seeing it among the pleadings.
I'm sorry.
I'm just not seeing it among the pleadings.
And so, Madam Hearing Officer, just to address your inquiry, what I'd like to point out is that the first amended administrative compliance order, paragraph 20, stated that submittals made pursuant to paragraph 19 of this order shall be sent by standard U.S. mail or certified mail with return receipt requested to the following address, Maria Medina Enforcement Coordinator. And that paragraph 19 of the first administrative compliance order specified the schedule of compliance that CRRUA was obligated to perform. The second amended administrative compliance order stated that submittals, then the second amended administrative compliance order, which was filed on May 23rd, 2025, stated that submittals made pursuant to paragraph 27 of this order shall be sent by standard U.S. mail or certified mail with return receipt requested to the same address. And paragraph 27 refers to the specific allegation that CRRUA did not notify the public of the April 23rd, 2025 test results only. So I think what CRRUA is trying to do here is draw your attention to the fact that the second amended administrative compliance order then makes the requirement after the results of those tests were communicated directly to NMED that somehow, I'm not sure how to, I have a feeling it's a typo, but I don't know. I mean,
I suspect it's a typo as well. I think they're talking about the paragraph 19 again, frankly, but
it's unfortunately it's a substantive issue that we need to.
And my only point
clear.
earlier was to say, it just seemed to me that Mr. Martinez had caught one set of references in the amended CO, but not this first reference to Ms. Medina in the second amended CO. That was my only point.
Thank you.
So, but let me not
I
further interrupt the
I
question.
very much appreciate you bringing that to our attention. And I don't know if I heard you testify this, but I just want to be clear because I know others have testified that after following both the April 23rd and May 6th samples, that CRRUA was still in compliance with the arsenic standard.
This has been asked and answered.
I don't think I've heard him say that. I mean, I know he said they weren't violations. I'm just,
Okay.
but there's a difference. You know, I mean, there's a violation and then there's, you know, they're still being in compliance.
I'll withdraw the objection.
All right, go ahead, Mr. Martinez, if you can.
Would you mind
No, not at all.
repeating the question?
After those tests, CRRUA was still in compliance with the arsenic standard.
That is my understanding, yes.
Okay. So can you please take a look at NMED exhibit is that 11? 11.
11. Okay.
I'd like you to, so this document, we've talked about it before. This is an actual arsenic violation, right?
Yes, that's what it looks like.
Like this, the RAA is above the MCL. They have violated. This is official notice.
Correct.
And what is the time frame that they must notify the public based upon this violation?
Just based on my knowledge of arsenic violations, there's a 30-day requirement for notifying the public.
So for an actual violation, there's a 30-day notice to notify the public. But in CRRUA's case, if you don't have a violation, then you need to notify the public immediately.
I would say that the 30-day requirement is the maximum amount of time that they have to notify the public, but given the fact that arsenic does have health impacts, you know, there should be made efforts to notify the public sooner than 30 days.
There should be efforts to be made when you have an actual violation.
Correct.
And you're saying that that also extends to non-violations.
I'm not saying that this particular public notice requirement extends to non-compliant samples. No, I'm not saying that.
So what is the requirement then? If it's not this, that they should have provided notice to the public at any point?
Sure. So our state regulations, there is a requirement that if the safety or reliability of the water is compromised in any way, that the public water system has an obligation to notify their customers.
And by when?
It doesn't say it doesn't have a specific timeline, but like I mentioned before, when there is an issue with the water system, they should make every effort to notify their customers as soon as possible.
So for an actual violation, it's not more than 30 days. For a non-violation, there's a different standard that you're saying should be as soon as possible in your interpretation.
Yeah, I don't think I'm saying that specifically, no.
Because if there's no date in the, so you're talking about two different legal standards, right? There's a legal standard that says for an actual violation, it's right here. It says the notice must be provided within 30 days from the date of this letter. This went to CRRUA saying you have 30 days to notify the public for this specific violation.
Correct.
And then there's a separate legal standard that you're saying has, whenever there's a situation, notify the public, but it doesn't have a specific time frame. But in your interpretation, you're saying that's as soon as possible.
I'm saying that given the circumstances of what was going on and has been going on with CRRUA since at least 2023, they had an obligation to notify their customers immediately when those samples came back elevated.
They had an obligation.
According to our regulations.
Where?
Our state regulations.
He's asked and answered this question.
I'm saying, there's been a lot of talk about there's a 9 and 3 day delay. It's not a violation, but there's a 9 and 3 day delay. And I'd like to know where the legal standard is that says that the 9 and 3 day delay was wrong, or that it violated a standard, or that it was, I'm trying to understand where that is, because you've testified that that is the essence of the bad faith enhancement. what they did after the test.
Madam Hearing Officer, this witness has testified that previously that is found in the regulations, and based on the circumstances, he expected that notice to happen as soon as possible. I think this has been asked and answered and is becoming argumentative at this point.
Okay, I think he's asking specifically where in the regulations is that?
Are you asking Mr. Martinez to recall off the top of his head the number of a regulation? Because he's already referenced that it's in the drinking water regulations.
I'm representing to him that there are two legal standards in the Drinking Water Bureau regulations. One, at least in regards to this, there was a 30-day notice, and then there's, you said, whenever the water is threatened, that they should notify the public in a timely manner. They both have discrete section numbers. But what I'm asking is, there's a specific, knowing that, right? You know that there's two legal standards, knowing that, because you've testified that what CRRUA did following those voluntary tests is the essence of the bad faith enhancement. And what CRRUA did is they didn't notify you, Tatiana, or Maria, because they notified NMED, the compliance office, and they notified the public 9 and 3 days after those samples. That's the essence. And I'm saying, where was the legal obligation for CRRUA to act sooner than 3 and 9 days, such that it would not subject itself to a 50% enhancement of a 6-figure penalty?
I'm going to maintain the same objection. And
Okay, I'm still trying to understand it myself, actually.
Would you like me to break it up? I can break it apart into individual questions.
I mean, you've now posed the question, I thought quite clearly 3 times. Setting aside the 30-day, I'm just going to give it a shot here. Setting aside the 30-day requirement for the compliance type samples, focusing instead on the other section of the drinking water regulations. What is it about that other section that requires notice in less than 9 or 3 days?
Unfortunately, it doesn't state specifically what the time frame involved that's required for that notification. So I guess that would be my answer.
That's fine. So what you're saying then is, with no legal obligation to act within a certain time, that CRRUA, in doing so 3 and 9 days after it did, subjected itself to a bad faith enhancement of 50% on a 6-figure civil penalty?
In our opinion, yes.
And your opinion, you're saying you personally?
No, I'm saying in the opinion of the department.
And that includes who?
it includes the department. I think he's answered that question. Who holds that opinion?
Is there anyone else that you had discussions with that said, I agree, that merits a bad faith enhancement of 50%?
Yes.
And who were they?
There was several people that we had discussions with, everybody from our deputy cabinet secretary, our general counsel. I don't recall everybody that was in the meeting, but it was there was some collective discussions.
Okay, so for the staff members, meaning, you and the deputy cabinet secretary, you looked at the 9 and 3 days and said, that's bad faith right there.
I think that in addition to their long history of noncompliance.
I'm sorry?
That in addition to their long history of noncompliance.
But you didn't use the history of noncompliance. You said that it was off of this.
Correct.
You didn't say that it had anything to do with long. You said that these are the factors that I looked at in applying the bad faith enhancement.
Objection, Your Honor. I think he's mischaracterizing the testimony. Mr. Martinez testified that He's aware of the history of noncompliance by CRRUA, and that was something he considered as he was reviewing the ACO and drafting the penalties.
That's my understanding as well. I think the department witnesses have been very consistent about bringing up the history of noncompliance.
I took very careful notes, and I don't believe that the record reflected that this witness testified to that in the slightest. This testimony was very
Mr.
clear, but the
Trujillo,
record is what the record is.
The record is clear that Mr. Martinez assisted and was aware of the 2016 ACO. He clearly testified that he was aware of the history of noncompliance by CRRUA.
It's not what point I'm making. The point I'm making is he very clearly testified. And we're going to move on. But in regards to the April 30th test results that were entered into evidence, NMED was notified on May 1st. Did you know that?
Which test results were you talking
That
about?
was the April 23rd, 2025 test results. I believe that Ms. Nixon entered the Eurofins report that stated that CRRUA learned about that on April 30th.
Correct.
And NMED was notified on May 1st. Were you aware of that?
I don't recall.
Were you aware of the requests for admissions that were submitted to NMED in this case?
No.
Okay.
I guess I don't.
So there was a request for admissions that were submitted to NMED, and it had a number of admissions, and that was one of them.
Okay.
And so are you saying that that delay was improper and would subject CRRUA to a bad faith enhancement?
I'm going to object to a mischaracterization of the evidence. The request for admission asks if the Southern Compliance Office was notified of the test results on May 1st, not NMED as a whole.
Okay, I would just draw the distinction that's already been made, and you've done it once already.
It's clear to you, Madam Hearing Officer,
is.
that the local compliance office received notice of those test results on May 1st, and we can move on.
Yes, that was in your motion a couple of times.
DFR. I think you mentioned, not sure if it was the, so feel free to correct me if this is wrong, but there's the April 23rd test, and then there's the May 6th test, and then there's the May 7th compliance sample that NMED took. And I think you made the comment that the May 7th sample increased. Do you recall that?
I do.
And was it your intention to say that that increase from May 6th to May 7th formed some kind of a basis for bad faith?
I'm not sure I said that specifically, no.
Okay, so you didn't mean that.
I don't recall saying it.
You drew a distinction between that. You said that they and the test results increased.
Correct.
And so I'm not sure what you meant. If like, well, if that's bad, that's more bad faith, or that's.
If I recall correctly, what my testimony was that the press release that CRRUA issued stated that they had made operational changes to lower the arsenic levels, and subsequent results showed that they were at the same levels or higher.
Okay, so it made public assurances, we're working on it, but then it came back a little higher.
Objection that mischaracterizes the evidence and the testimony. The press release says they have lowered the MCL to below that, or lowered the arsenic level to below the MCL.
So are you familiar with all of the voluntary arsenic tests that CRRUA has performed starting with May 14th to the present?
No.
You probably didn't hear about them because they weren't exceedances, right?
Objection. Foundation, he just said he's not familiar with them.
Okay, but he can.
You
I
would
think
have
it's a
heard
good question.
You would have heard about them if they were violations or exceedances. Two different things.
I believe they would have been reported to me at some point.
So an exceedance or a violation would have been reported to you. So they weren't reported and what about the quarterly compliance sample for the third quarter of 2025 in July. Are you aware of that?
No, not directly.
Okay. And if that had been an exceedance or a violation, you probably would have heard about that.
Which sample date are we talking about again?
July 2025.
No, I would not have.
If it had been a violation or an exceedance, you would not have heard about it.
Absolutely not.
They would not have reported violations or exceedances to you.
No.
In this case.
No.
You are the bureau chief of drinking water.
Yes.
So you don't get information about violations.
No, not as of July 1st, 2025.
Oh, I'm sorry, because it's split.
Correct.
Yeah, your workload went down.
It didn't go down, but that specific work is not
changed.
within my purview any longer.
It changed. Okay,
Yes.
I'm sorry. I didn't catch that. Now, when it came to the so when it comes to, so you've got, as Ms. Nixon pointed out, you drafted the administrative compliance order for March 1st, 2024, or you were aware of it, you know it. It's something that you're familiar with.
Objection misstates the testimony. Mr. Martinez has testified that he reviewed the first amended.
I'm sorry, you reviewed it.
Correct.
And was it, so there's a penalty that's set forth in the March 1st amended administrative compliance order of 251,500 and something. I'm not sure the exact number.
Mm-hmm.
You're aware of that?
Correct.
And in the second amended administrative compliance order, there's a different penalty. You're aware of that?
Yes.
Okay. Who calculated the second penalty? It was you personally? You personally recalculated it?
Are we talking about the $168,000 penalty?
No, I'm talking about the one that's in the second amended administrative compliance order, the 252,000. I think it's a round number. No, I'm asking is that there's an second amended administrative compliance order that has a specific penalty.
Okay.
I believe it's I think it's in front of you. You can turn to the end. Just to
$252,000.
$252,000. I think your testimony was that you recalculated, like you literally recalculated?
Yes, I was involved in that. Yes.
Okay, so it was a group effort. It wasn't just you.
I was working with our attorneys at the time.
I'm sorry?
I was working with our attorneys at the time, but yes, I did calculate that penalty.
You were working with your
attorneys.
Oh, I'm sorry. I can't. I'm slightly hard. I'm more than slightly. Okay, so it was a team effort. You worked. Did you perform the mathematical calculations?
I believe I did.
Okay, and what were the steps you took to perform the mathematical calculations?
I don't recall specifically the steps I took.
And I believe your testimony was that in recalculating that penalty, you were working off of a penalty of approximately 168,000 after some tweaks had been made to the original penalty, right?
That sounds correct.
Okay, so there was 168,000 that then resulted in 252,000 for a difference of 84,000, right?
Yeah,
I'm like that too. You tell me that
I'm
the
not
math
good with
adds up.
math on the fly, but I will take your word for it.
Right. So, I mean,
one at a time, please.
Sorry. And how familiar are you with the penalty policy that you applied in the bad faith enhancement?
I wouldn't say that I'm an expert in it, but I'm fairly familiar with it.
Okay. And so, based on your understanding of the penalty policy, there's a sequence of events, right?
Object to foundation and mischaracterization of his testimony. He didn't say that.
Do you know that there's a sequence of events in the penalty policy, or did you hear Ms. Medina's testimony earlier today where she described, setting an initial penalty, calculating the days, evaluating for good or bad faith, and then arriving at a penalty?
Yes.
You heard that?
Yes.
And so there's 3 initial steps there, right? Setting an initial penalty, calculating the days, bad faith, good faith, penalty.
I believe that's what she testified to, yes.
And your testimony was that you recalculated the penalty based off of new information that you learned or that NMED learned through the course of the proceedings.
Yes.
And that new information, the test results, and how CRRUA responded to them.
Correct.
So you then went back to apply a bad faith penalty to CRRUA's $168,000 amended penalty.
Yes.
So in your estimation then, the test results that were not violations and the public notifications that were not violations merited an $84,000 enhancement, right?
Yes, in our opinion.
In fact, I think you testified that there's a range, right? There's a range of 0 to 50%, and that you felt that based on the test results that were not violations and the notifications that were not violations, CRRUA needed to be assessed the maximum 50% bad faith enhancement, correct?
Yes, in our opinion.
So without that bad faith enhancement for non-violations and for this delay with no legal obligation to support it, CRRUA will actually owe $168,000 for the
Objection,
civil
Your Honor.
penalty.
This is repetitive. He has testified numerous times what the penalty would have been without a bad faith enhancement, as well as the value of the bad faith enhancement.
Haven't we heard this?
I don't know. I mean, like, I'm just walking down the line, and
The questioning is getting repetitive, and that's the objection.
Right. So
it's not asked and answered. I haven't asked it that way. I'm just asking.
But the question has been answered, so therefore it's a repetitive question and a proper reason to limit the scope of cross-examination.
Okay, thank you. Yes, please, to the extent you're just eliciting repetition, move. I distinctly remember 252, 169, back to 252. We have heard that.
I think you also mentioned that the CFRs, they have regulation, they have regulatory, requirements for arsenic in the level. And I think you stated because long-term ingestion is noted in the CFRs as a concern, something to that effect.
No, I don't think I stated that. The regulations don't specifically state anything about specific health impacts.
Sorry, was it EPA guidance that says that?
Yes.
So the EPA guidance said like long-term ingestion is a problem.
Yes.
because CRRUA is in compliance with the arsenic standard. And from April 23rd to May 14th, when CRRUA returned its first test following that were below the levels, is a period of about 2 weeks, right?
Objection, Madam Secretary. He testified he doesn't know what the May 14th results are, and the period of time from April 23rd to May 14th is longer than 2 weeks.
Is it 3 weeks?
The same objection.
Okay.
I can go over, I don't want to go over all the test results. So we could just enter the RFAs into evidence and then, I mean, we submit CRRUA's exhibit 24 to evidence.
Okay.
RFAs.
Hold on. You have an objection, Ms. Nixon?
No objection.
All right. CRRUA Exhibit 24 is admitted. And if you just want to count the days or weeks yourself on the calendar, that won't be a dispute.
Hey, approach.
Yeah.
And
Thank you.
Mr. Trio, could you just direct my attention to what RFA you're
CRRUA Exhibit 24, request for admission number 35.
Thank you.
Following the April 23rd, May 6th, and May 7th test, CRRUA conducted a series of voluntary tests. And can you tell us what that RFA says in regards to the May 14th, 2025 test?
Are we talking about number 35?
Yes.
The states admit that the results of the voluntary test sample conducted at the the industrial park arsenic treatment plant on May 14th, 2025 was below the MCL for arsenic.
And what does it say below that?
Admit, and there's an X on that line.
Thank you. So the window that we're talking about is April 23rd to May 14th. And I represent to you that that's 3 weeks. Do you have any reason to disbelieve that?
No.
And so these non-violations that took place for in a scope of 3 weeks is what partly what constitutes bad faith on CRRUA's part.
Objection. This has been asked and answered and is highly repetitious. I would ask that we move on from
I think
this
it's a
line of
different context. It's
the question has been asked and answered, and your questions are repetitious.
I'm sorry. So I guess I feel like you have covered this before. How is it different?
I'm sorry.
How is it different?
What I was saying is that that not only is there a mere fact that there are non-violations with non-legal obligations that are triggered, but it's a window of 3 weeks in the context of the many hours of testimony that have given that CRRUA is in a cycle of non-compliance or it comes in and out of compliance. I mean,
At this point, counsel is just making an argument.
Okay.
well, I'm responding to the objection. There's an objection on the floor.
She asked how it was different. You're making argument on behalf of CRRUA.
Okay. Hold on, Ms.
Yes.
Nixon.
Yeah.
Mr. Trujillo, it is self-evidently 3 weeks on the calendar,
Thank you.
and we've spent altogether too much time with you trying to drop those words from Mr. Martinez's lips. Can we move on, please?
Sure.
Okay.
One. No further questions. Madam Hearing Officer.
Thank you, Mr. Trujillo. Ms. Nixon, do you have any follow-up?
I do, Madam Hearing Officer. Thank you. Mr. Martinez, I know it's been a long couple of days, so I won't take too much more of your time. I'm going to start where Mr. Trujillo started. Do you recall that he asked you some questions about the monitoring sample that was taken at the Love's truck stop down in the CRRUA area?
Yes.
Was that monitoring sample used for compliance purposes in this case?
No.
Was it used for the purpose of calculating any part of the penalty in this case?
No.
And you did not draft the press release, correct?
I did not.
Did you request that the press release be drafted?
No.
Did you know that a press release had been drafted?
Not that I recall, but I am involved in a lot of press releases, so I may have been informed about it.
Next, there was a lot of discussion with Mr. Trujillo about the extension of time that CRRUA was granted to come into compliance with the 2016 ACO. Do you recall those questions?
I do.
And to your knowledge, those extensions for compliance, were those requested by CRRUA?
I believe they were.
Because CRRUA couldn't timely come into compliance, right?
Correct.
And there was a long soliloquy of questions about the contact to the appropriate person when the voluntary samples were received. Do you recall that?
I'm sorry, could you repeat that?
Do you recall the line of questions, the long line of questions about CRRUA's obligation to contact certain persons at NMED with the voluntary sample results?
Yes, I do.
And to your knowledge, at the time that those voluntary samples were taken and the results received, so in April and May of 2025, to your knowledge, were settlement negotiations occurring?
I believe they were.
And to your knowledge, was Ms. Engelman or your contract counsel of record in this case contacted about those samples?
Not to my knowledge.
The timeliness of the notification from CRRUA was not a violation. We know that, correct?
Correct.
And I'm talking about the timeliness of the notification of violations or the voluntary samples.
Okay.
But what does the delay in CRRUA providing that public notice suggest to you about CRRUA's good or bad faith?
Oh, I'm object to that. I think that's speculation. And I don't even know if he's informed an opinion on what a delay that has no legal obligation to perform could be construed to be in good or bad faith.
To avoid speculation.
Mr. Martinez, in your role as a regulator, given all of the circumstances of this case, which you have testified you were aware of, what does the delay from the time CRRUA received the voluntary test results to the time it published those results say about CRRUA's good or bad faith for purposes of application of the penalty policy?
I feel that CRRUA should have notified their customers as quickly as possible, and because they didn't, that could be construed and was construed as a bad faith effort on their part.
And you testified earlier that the letter from Empowerment Congress helped inform your knowledge of customer complaints.
Yes.
Did the volume of customer complaints impact your analysis when considering whether that delay constituted bad faith?
I'm sorry, could you ask that question again? I'm sorry.
Did the volume of customer complaints impact your analysis about the bad faith of CRRUA for the delays in notifying their public about the voluntary arsenic test results?
Yeah, I think that the complaints that not only that letter had, but also the complaints that we received as a department do demonstrate that the customers should know sooner than later when their water quality is being impacted in any way, in any negative way.
Thank you, Mr. Martinez. I have a similar question.
Sure.
Does CRRUA's history of non-compliance, as you've testified about today, also help inform your discretion when evaluating the bad faith adjustment?
Yes.
And in what way?
I think the history of non-compliance shows that they have not worked in good faith over the years. I feel like our department has worked in good faith by agreeing to settlements, by offering extensions, by doing various things, and we're still here. And so that, to me, that shows a long-term bad faith on their part.
Mr. Martinez, if CRRUA had reached out to Maria Medina before July 1st, 2025, regarding the voluntary test results, would she have reported that to you?
Yes, I believe she would have done that.
And did she report that CRRUA had reached out?
No.
Do water systems have to report any problems or certain problems with their system to NMED, regardless of whether they have counsel?
Yes, according to the regulations, they should be reporting those things to both us and their customers if the safety or reliability of their water is endangered in any way.
And based on your knowledge as a regulator, having read the EPA guidance about the health effects, did the individual arsenic exceedances on the 3 occasions we've talked about compromise the safety and reliability of CRRUA's water?
While they did not constitute an actual violation, the fact that they were still above the arsenic standard did compromise the health of their customers.
And does the fact that there is an active ACO or an unresolved ACO change any of those reporting obligations?
No.
Would notifying the public due to about the arsenic results, even though they weren't compliance results, be a matter of simply compliance, or is it broader than just compliance?
Oh, I feel it's broader than just the compliance issue.
Can you tell us why?
Because, as I mentioned before, a big part of drinking water regulations is notifying the public so that the public can make informed decisions about whether or not they want to drink that water. And also, you know, as part of effective operations and management for any water system, they should be transparent about issues that are going on with their system.
Just a few more questions, Mr. Martinez. You heard testimony earlier today and some questions from Mr. Trujillo during your cross-examination about the number of voluntary tests that CRRUA has conducted, correct?
Correct.
And in your mind, how does the fact that CRRUA is simply conducting those tests play into your analysis about the bad faith enhancement?
Well, I think the tests that they're conducting now are good practice and general good operational practices, and those things should have been being done all along. And so it's not something that you know, we would generally give a water system credit for. You know, it's something that is just basic operations for a water system.
Going back to those adjustments we talked about, the penalty policy awards or affords NMED the discretion to apply those, correct?
Correct.
Based on the listed factors, correct?
Correct.
And in making the decision to apply the bad faith enhancement in this case, did you exercise your discretion in accordance with the penalty policy?
Yes, we did.
And you testified that there's some competing considerations when you're evaluating the amount of a penalty to be assessed, correct?
Correct.
And the ability of a system to pay the penalty without substantial effects to their public was one of those considerations.
Correct.
And but on the other hand, you also consider the necessity for the water system to understand the gravity of noncompliance.
That is correct.
And is that latter factor, did that weigh in your decision to apply the bad faith enhancement in this case?
I think it's always in the back of our minds when we're calculating penalties.
So it's true for this case also?
Yes.
No further questions, Mr. Martinez. I appreciate your time today.
All right, thank you.
Thank you.
Ms. Nixon, any reason not to excuse Mr. Martinez? No?
Nope.
Thank you very much, Mr. Martinez. You're excused. What I'd like to do, is there any good reason to believe we're going to finish by 5 today?
No.
I don't think there's any realistic way.
Okay, so I'd like to go off the record because I don't think we need our calendar comparisons on the transcript. And we will take a short break before we go to your presentation, but let's talk about the schedule first.
Okay.
Okay, thank you, Kim. Usually what I do is I just pull out my comically oversized paper calendar here and start walking through the days until I don't have an objection.
Okay.
So the first day we could possibly resume is tomorrow. I have other things, but they are movable.
Madam Hearing Officer, NMED, Council for NMED also has other things, but we're willing to move them to continue tomorrow.
Okay.
I cannot. I have one of the federal Indian water rights adjudications. We have a mediation session set with a bunch of different parties. I can't move that.
Okay. And is that all of tomorrow?
It is for most of the afternoon, but I also have, I try to change the meeting, but it's from 1 to 5.
All right. So you don't think I'm just asking, the morning is a possibility? No?
I mean, I have things I could move, but I don't think tomorrow would work. I would have to probably break
All right.
like 11:30 to be at the other session by 1.
Okay, what about Monday?
I have a conflict. We also need, our folks are coming
Yeah, we have
from
to,
the south, so, and they run a utility.
when,
So,
Okay.
but
when's the
we
next
have a
time
board
you guys can come up here? Huh?
Tuesday?
Oh, but you're be teaching. You can't do it when you're teaching.
Would it be possible to come up a day early on the 8th?
CRRUA has a board meeting on Monday, May 8th, a regular monthly meeting.
Okay, so is it possible to salvage any of the 9th if we were to take one witness in the morning and the other one in the afternoon, for example? Is that
yeah, there's a person.
okay? That's fine.
Yeah.
That's I'm just trying.
Yeah, no.
What about the 10th?
Unfortunately, we will not be available on the 10th.
Okay, and I'm not available on the 11th or the 12th.
I have a surgery scheduled for the 11th, Madam Hearing Officer, but
I'm not available on
you're not
the
available
11th or the
Okay,
12th.
sorry.
Not at all the 12th then?
No, I'm going to be away from all devices.
Good for you.
And, I have a haircut at 1.
Can't move that.
My hair won't look this good. All right, let's see. What about the 15th?
No,
No.
we've got a big meeting on the 15th that's been in place for months.
Okay.
16th
16th.
16th is okay.
But,
AC, you might already be up here. Well, not here, but
The 16th is my birthday, but we'll be available on that day.
I'll bring a cake.
Even more reason to
well,
be.
let's not do that then.
No, please, let's do it on the 16th. I would love to. I'm old enough that birthdays don't matter.
They matter no matter
he
what.
takes his birthday off. I know that because he has the same birthday as my son, but I always work on my birthday.
I'm not taking it off, so I'll be here.
Yeah.
My 87-year-old mother would just disagree with you. Still celebrates.
Yeah.
All right, so the 16th, and Luis, do you see, and maybe make sure Pam is still on the platform. I have a mysterious.
I'm here.
Okay, Pam, I have a mysterious reference. I don't think it's League of Women Voters. I think it's a reference with you guys, but it's at 11 a.m. Do we have something at 11 a.m.?
On the 16th?
Yeah.
It used to be something with the hazardous waste 24-33, but I've erased it, so it must not be.
Okay. All right. I'm just double checking because I don't understand my own writing here. Okay.
You have a status conference on the 15th with the Air Quality Bureau.
Yeah, I saw that. AQB 2472. Also, the regional haze findings are coming in on the 15th. Okay. So the 16th works for folks.
Yes, ma'am.
Yeah. Okay.
Well, not for me, but I'm not an important person.
Thank you.
You're the most important person, Kim.
There's plenty of us out there.
All right.
I will let the office know. Ma'am, will you let the office know?
CIG. All right, so let's come back, resume on the 16th at 9 a.m.
Madam Hearing Officer,
yeah.
I have a question then.
Yeah.
Since NMED has basically completed its case at this point, do we want to start and stop at this point? I mean, I'm saying, do we want to start Mr. Crosby, or does it make sense just to start to start CRRUA's case in chief on the morning of the 16th and just blow through it.
Yeah, we are having exactly the same.
Oh, okay.
It makes sense to us to do it that way.
Yeah, because
To wait till the 16th?
yeah, because I was going to start Mr. Lopez, and I'm not even sure I would get through. Well, I would probably get through as direct, but I don't think we would get through directing with Mr. Lopez today. So we'd be cutting off either sometime during direct or some during pause.
We don't object to that plan to start over if that's okay with your hearing.
Okay, to end for the day and then resume
Yes.
with their presentation. Okay. And if someone would just make me a note, I really don't have the first amended CO. Would you send that to me or send it to Louise so I can have it?
Of course. We also have a printed copy if you'd like one.
Oh,
now.
that would be even better. All right. The mysterious reference is in fact to the League of Women Voters. Okay. I can skip that.
September 16th then.
Yeah, 9 a.m. Yes, of course. Thank you very much.
So Jessica, is your birthday 16th? Or is it?
Oh, that is?
Oh, it's the 16th. Okay. All right. Sorry. Yeah, right. Yeah. Yeah.
Are you gluten free or anything? No. Okay. All right. So then let me add. Oh, so let's go back on the record. Thank you, Kim. We're coming back on the record just briefly to say that we have worked out a date to resume the hearing in this matter. It will be September 16th at 9 a.m. Mr. Lopez will be informing us of the location because it's harder to do that on the fly. And we will ask for a court reporter. I'm sorry, we'll lose you, Kim. And instead of proceeding just a little ways into the respondent's case, now that it's after 3:30, we're going to pick up on the 16th with the entirety of the respondent's case. There was one thing I wanted to do just before the department says they're completely done. I wanted to be explicit about what exhibits were marked but not admitted, just in case you had some cleanup to do. 7, 8, 16, 17, 21, 22, 23.
Madam Hearing Officer, would you mind reminding us which of CRRUA's exhibits have been entered?
Yes, CRRUA's exhibits that have been admitted are 2 and 24. That's all I got. 2 and 24.
The list that you read of NMED's exhibits are the ones that have not been admitted, correct?
Correct. That was what I was reading.
Thank you.
Do you want me to tell you what they are? Or
No, I was confused, Madam Hearing Officer. I thought you were saying the ones that were admitted, and I said, no. Yeah, so my bad.
That's all right. It's getting late in the afternoon. Okay, so is there anything else we should do before we break?
Not on behalf of the department.
Is there a hotter room?
Anything else we should do before we break?
Any what?
Anything else we need to do before we break for the day?
No.
No?
Right? No.
All right.
Sorry.
Thank you all for participating, and we'll see you again at 9 a.m. on September 16th.
Thank you.
Thank you.